哦。 你中意擺個手機喺嗰度㗎嘛 ？Henry 都唔係同你傾偈。係啊，搞掂咗啦份功課。不過我覺得俾你睇唔數啊。
common law 嘅 concept 係啦。冇，呢個小心，呢個係Cambridge Registry 佢 publish 出嚟嘅 guideline 嚟嘅。
但係因為啲內容同你講嘅嘢。
係啊，因為佢將個 law summarize 咗。
咁所以。
但係呢啲唔係 law 嚟㗎，呢個係佢方便，即係佢做一個指引。等一啲係冇即係唔識 law 冇正式讀過 law 嘅人，咁一個簡單嘅guideline大約知道講乜嘢。所以佢會好似我講嘅嘢，因為佢將個 law 嘗試將個 law summarize。咁但係咧就佢本身唔係，即係呢個唔係 law 嘅 source，即係呢個唔係一個 law 嘅 source，所以我陣間會同你睇一睇㗎，唔好直接 call 呢度嘅嘢。
即係其實都唔使 call 啦，因為
唔使 call 呢個係啦，你講 law 呢個唔係嚟㗎，即係呢個係 secondary information，呢個係啦，即係 secondary information 係嗰啲人 base on 個 law 佢自己製造出嚟嘅，嗰個本身唔係 source of law，你要 call source of law， 你可以睇，但係唔好直接 call 佢出嚟。可以唔 call 呢個直情唔需要 call 呢個。但係你要 call case 咯，如果你答 assignment 一定會有 case。小心你個熒幕，你可以擰轉下面，你唔好望住呢邊，你笑住隻眼。
咁我 call 翻嚟嗰啲。
當然可以，當然可以。
嗰個 format 我分得好清楚，其實我係一時過㗎，因為我係聽。
冇一定嘅，因為冇一定，即係冇話一定要點樣寫嚇，冇話一定要寫。個格式。係啦，我又冇可能話寫到咁死，但係咧就嗰個 IRAC 係啦，但係要表達到呢個意思咯。咁但係就就唔好 point form， essay form 係啦。但係我會提議你都要睇個 structure， 加個 topic sentence 啊 heading 啊，一個 paragraph 講一個 point 咁上下意思。就算我係 start with issue， 我表達都唔好就咁一句就算咗。唔係，我諗唔係呢個問題，係呢個你每個人嘅個 writing style 好難講話一定係要點樣寫。總之我就覺得個 structure 好緊要啦，即係總之你諗嘅方法令到人哋容易睇嘅咁樣最好，但係就唔好 point form， 即係唔好 bullet point 一個 point 咁樣，即係要一個 paragraph 咁樣。應該我睇一睇大家。咁樣咧，你繼續講，唔好意思啊，我 set。
咁頭先你話嗰個就係 law 啦，咁咧你咪仲有講到話作為一個 director 要有佢嘅 level 啊，咩 duty
係
of care。
唔係 duty of care 嗰個叫做一個 level of competence。係個 competence 即係話佢嘅能力嘅問題，嗰、個唔係快啲需 duty。
咁所以個功課都唔使 mention。
我唔可以答你呢個，呢個唔可以答。
好啦。
係，但係就嗰個係另一回事啦。即係總之嗰個另一回事。嗰個能力嘅問題，同埋佢做一樣嘢係啱與錯係另一問題。fiduciary duty 就講一樣嘢係佢啱與錯，即係可以做唔可以做。level of competence 係佢做一樣嘢係冇問題，但係你做一樣係正確，但係都有個能力之分嘅。即係我教咗，我喺度我教中國歷史，咁我就完全係必做fiduciary duty，因為佢做一樣唔啱嘅。但係我教緊我，但係你都可以教得好好，仲教得好差。咁佢就係要求法例就要達咗個合理嘅水平。如果唔係，你都可能會必咗 company ordinance 裏面 impose 咗你嘅 duty， 但嗰就唔係fiduciary duty， 係叫 level of competence， 即係能力嘅範圍。係啦，咁可以話俾你聽。 shareholder 本身唔可以代公司做決定嘅，呢啲上面啲啊，邊個人先係代公司做決定啊？大家所以 shareholder 只係某一啲嘅嘢佢先有權講，即係 law 同埋 article 裏面講嘅嘢。general 嘅 administration 係屬於法律。但 members 冇權炒人，直接。你記得我講 members 只可以喺某一啲嘅嘢裏面去投票，但 members 本身唔係直接管理間公司。但係你要知道嗰樣嘢本身係 law 或者 article 講咗佢可以投票，咁佢先關事。如果唔係一般嘅人係唔關事，佢冇權利。咁我相信一般炒唔炒嘅人，有冇投票自己關。我知道真問題。我知道真問題。因為我聽人，我聽就係從你答我嘅嘢，或者同你問我嘢，我就知你想問乜嘢。呢個就係我嘅分別嚟嘅。個 part of my training。但你留意我呢個 concept，我啱同你講過。Before we start the class, please turn to page 30. There's a typo error here. Page 30. Typo error. 呢度同埋呢度。睇到呢兩個位置，睇唔睇到？啱啦，就係呢兩度。A new charge, right? Not a fixed charge, new charge, right? In page 30, the typo error is here. Because they printed the wrong version. But you don't have to take photo, right? So simple. 兩個位，係咪少錯咗？佢印錯咗個舊 version， 我改咗佢唔驚。
即係唔要個 face 嘛？
總之你跟翻呢度，你跟翻呢度。記住silent 嗰度，咁啊中途電話響，我會聽嘅，我會關嘅。So, is it okay, everyone? Page 30. Right, remember, the two typo errors here. before we start the class, any question about the assignment? Any questions for the assignment? Okay. Something I have to remind you before we start lecture line about the assignment. All right. Regarding the work limit, the official requirement is 2,000, right? 2,000. So I think the optimal length would be around 1,500, so not more than 2,000, right? I'm not having a very strict requirements on the word count. I don't think that's really important, provided that you have a good answer, right? Provided that you have good argument. So sometimes a little bit longer will be fine, right? Sometimes a little bit short will also be fine, right? So I don't have a very strict requirements regarding the word count. But somewhere between 1,500 and not more than 2,000, I think that will be optimal from my experience, right? So not too much or too less. Another thing, when you search the internet, in the website of the company registry, you find something called the guideline for directors, right? So you can take a look and you can take reference from this guideline, but you cannot quote anything from this thing directly to support your argument, because this guideline is not law, right? It's not the source of law. That's only a summary prepared by the company registry, but that's not the source of law. If you want to quote authority to support your arguments, so you have to quote the section numbers, right? You have to quote the section numbers of the company ordinance, and you have to quote cases, or you can quote judgment, or you can, so anything being mentioned in class, but you cannot quote a guideline to support your argument, because a guideline is only a guideline. This is not law, right? Do you understand my point here? Right? Because this is not law. This is only a summary, right? Summary. And this is not a source of law. So you can always find the guideline, say like in the IRD, in the company registry, or in the SFC, right? So that will be for the sake of convenience. If you're a lay person, right? If you know nothing about the law, so then you can take a look. It saves time, right? It saves time, and it's helpful, but you cannot quote it as a source of law in order to support your argument, right? But that's not the source of law. That's only guideline, the summary only, right? So take a look, but don't quote, all right? Don't quote, right? Be careful. One more thing I have to remind you. In Hong Kong, our written law being called as an ordinance, right? In UK, they call it Act. So in Hong Kong, we have the company ordinance, and in UK they have the Company Act, right? They have the Company Act, Company Law Act. So don't quote anything from UK with Act, only ordinance, right? But that will be a fundamental error. It means that you don't know the jurisdictions of the law. That will be a serious problem, because you are studying a law in Hong Kong, right? You're not studying a law in UK. I know that they are similar, but not the same. So if you want to take reference from a UK textbook, you can do so. But be careful, right? Don't quote any UK act. So that will be a serious mistake, right? So don't do it. Because I always found mistake of my previous students, right? They're always making mistake by quoting the wrong sources of law here. So you have to be careful, right? Okay, if you don't have any question regarding the assignment, so let's start the class. So lecture line, all right? Lecture line. Okay. We we spent a few minutes to talk about lecture 8 first, right? So what we learned in lecture 8. So we learned about shareholders, general meeting on lecture 6, and we learned about directors on lecture 7, right? So they are the two most important organs, the general meetings and the board of directors in the management of the company. So in lecture 8, we learn about problematic areas. It means that even the board of directors functioning very well, and even the general meeting functioning very well, but sometimes problems still arise because of two problems here, because of two principles, right? What are they? What are the two principles? The majority rule and proper plaintiff rule, right? Majority rule means that a company always being ruled by the majority. But the majority rule can only ensure that the majority, they are in control. It cannot ensure that the majority, they are making good decisions for the company or for the minority, because they can be bad guys. They make decisions at the expense of the minority, right? Number 2, public plaintiff rule. So why public plaintiff rule is a problem? Why is it a problem? Number 1, what's public plaintiff rule? Any of you still remember what's public plaintiff rule? Quite simple. Only the company can sue when wrong being done to a company, right? Because based on the Solomon principle, separate legal entity. Company is an independent legal person, independent from the shareholders, independent from directors. So if a harm being done to the company, who is to sue? Not the shareholders, right? Even you suffer, even you own 99%, even you own 100%, you are not the one to sue, but the company to sue. But usually, the bad guys, they are the ones in control of the company. And the company actually being managed by the bad guys. And the bad guys will not procure the company to sue themselves, right? So we have a dilemma here. How do we solve the problem? The law offers the remedies. And what are the remedies? Just name, right? We don't have time to get into all the details. Yes. Any of you remember? So what are the remedies being offered by the company ordinance? Well, this time we have to rely on company ordinance. Unlike fiduciary duty. Fiduciary duty is only a common law concept. It means cases. But this time, right, when we want to fight the bad guy, we have to rely on company ordinance. So the company ordinance offers two remedies here. So number 1, come on. Oh, okay. What? Anyone give me the answer? I have a scholarship for you. I'm serious. What? Sorry, order, restraining order. No, we have two options available for the one who suffer, right? What you can do? Come on, I'll get a scholarship here. Ready?
What is it?
Unfair prejudice.
Unfair prejudice. Right, that's one of it. It means that you can make application to the court, right, as a member, that your right being harmed, which is unfair and prejudice to you. What's the another one? Except for Simon, anyone? Oh, come on, very simple.
Winding up.
One of it. SDA. Statutory. What is it? What's SDA? Statutory derived action. What it means? What it means?
You can, on behalf of the company to sue the bad guy.
To sue bad guy, right? And okay, you get my scholarship, right? this is alcohol, so you can rub your hand, right? This is the price, right? You get.
I have.
都俾過你，係。呢個唔同呢個，我幫我開光過呢個。Okay, alright, okay, you get the price, right? Good, right, very good. Okay, so that's what we learned in lecture 8, right? So let's start lecture 9. Okay. So at the very beginning, right, I think that's lecture 3. We learned that the company is only a vehicle, right? A company is only a vehicle. What I mean by vehicle means the company is neutral. So don't be misled by the name of company in the daily usage. Because in Cantonese, right? Whenever you refer to a company, so normally you refer to a business. But that is not true, strictly speaking. Because a company is only a vehicle. A company is neutral. It means that you can use a company to do many different things. And run a business is only one of it. But you don't have to, right? You don't have to. You can use a company for charity. You can use a company just to hold assets. Or you can use a company just to avoid risk. Because a company itself is neutral, right? That's what you learned at the very beginning. That's true. That's true. Always true. But in reality, I would say most of the company are being incorporated for business. Right? In real life, most company being incorporated for business. It means they try to incorporate a company to aim for profit, right? To aim for profit. I mean, they are aiming for profit, right? Aiming for profit. That's not a requirement, unlike partnership, but that's the case for most parties when they incorporate companies. Okay. So far, we learned a lot. We learned about the structures. We learned about the mechanism of company. But it seems like one thing we missed it. Before you can make money, what you need before you can make money?
Bank account.
You need a bank account.
Capital.
Capital, right. So you need money before you can make more money, right? So you need money, right? You need money, right? You need capital first because that's investment. You have to invest before you can make the big bucks, right? To make the big bucks. Okay. So for a company, we call it financing, right? Financing of company. So this is another very important area of law that we have to learn, right? Financing of company, or sometimes we call corporate finance. I'm sure that you heard about this name, right? Corporate finance. So what is it? Financing of company. So company need money to operate their business. So the process in raising money we call corporate financing, or just corporate finance. But corporate finance or corporate financing is not, strictly speaking, a legal term, right? It's only a business term, just like merger, acquisition, right? Merger, acquisitions, they are not legal terms. They are business terms, right? Only business terms. But somehow we understand what it means, right? We have a rough idea for what it means. But remember, this is not a legal term. Director is a legal term. General meeting is a legal term. Order resolution is a legal term, right? Separate legal entity, independent legal person, they are all legal terms. But merger acquisition, they are business terms. And corporate finance, business term. It's not something you can find in the company ordinance. But somehow we understand what it means, right? Okay, how to make money? How to make money? How to raise money? Raise capital for the company. Number one, back to basic. So how we describe a company? Legally speaking, of course. How we describe a company? As what? A company is what? Legal person, right? It's a legal person. Independent legal person. So just like the other person, or you are a person, right? Or you. When you need money, what you need to do? When you need money? You borrow, right? You can get a job, but it takes time, right? Or you can rob the bank, right? But that will be very risky, right? You have to buy the gun first, right? So, just like a normal human being, like a person, right? Natural person. when you need money, you can borrow. You can borrow money, right? You call the bank, right? You call partners. There are all kinds of financial institutions in Hong Kong, right? That would be quite easy in borrowing money. But a company is like a normal human being. A company can also borrow money, right? So there are two different ways for a company to raise funds. Number one, borrowing, right? Just like a human being, just like a natural person borrowing money, right? Because a company is a legal person, right? A legal person can exercise all the rights as a human being, apart from the biological function. But there are another way, apart from borrowing money, issuing shares. Right? Suppose the company is a private company limited by shares, right? Suppose the company has shares. Because I hope that you still remember, unless otherwise stated, normally, right, you can refer to the notes on the assignment or even an exam, you are dealing with a private company limited by shares, because that is our focus, right? Okay, so a company, apart from borrowing, a company can also issue shares in order to raise funds. I hope that you still remember. That's what you learned in lecture 6, right? That's what you learned in lecture 6 regarding shares capital. So it means that a company can issue shares to pin the paper to you and return with your cash, right? So once you pay the cash and then you subscribe to the shares, your cash will become the capital of a company. It will become the asset of a company. And the company can use it, right? The company can use it. And normally you cannot ask the company to return the money to you, right? Normally not. Only for some exceptional circumstances, like when you have the redeemable shares, right? Or the reduction of capital, but that will be a very advanced topic, not being covered in our module. Just normally, you cannot ask for the refund, right? So the company can raise money by borrowing, just like a natural person. Company can issue shares to raise money. And this one is only available for a company. It's not possible for a human being, right? It's not possible for a partnership. Not possible. A partnership or human being, I mean sole proprietor, and partnership can only borrow money. A company can borrow money and also issue shares. So in legal terms, when company borrow money, we call loan financing, right? Loan financing. When a company raise funds by issue shares, we call equity financing, right? It's an equity, something like asset. Right? It's accounting terms here. So equity here is not the source of law, right? Right? No, this is not one of the sources of law in Hong Kong. I mean, in this topic, we are using the accounting concept here regarding equity. If any of you have a business degree, then probably you understand what I mean here, right? Equity, something like asset, right? Something like asset. Not equity law, right? In this lecture, not refer to equity law, right? In my humble part, but asset, all right? So we have two different ways in order to raise the capital, to borrow, loan financing, to issue shares, equity financing. So let's take a look at equity financing first, right? So remember, equity here, it means asset, right? Asset. So equity financing is a method of raising fresh capital by selling shares. Selling, right? Selling shares. Why selling shares? Because you have to pay for it. You have to pay for it. You pay the company, you get the shares, then you become one of the members, right? And the company get the money. And remember, the shares capital, once being paid off, shall become asset of the company. And you cannot ask the company to return back to you normally, right? Bear in mind, very important. Okay. What is the advantage to raise funds by issuing shares when you compare, right? So because normally we have two different ways to raise funds for the company. We can borrow or we can issue shares to raise funds. So what will be the advantage? Think about it. For a company to raise funds by issuing shares. You have the hints here, right? So any of you have accounting background, or any of you, I'm sure some of you, right, have a business degree, or you are accountant. Can any of you help me by looking at the financial statement? What's the difference when you borrow money or when you issue shares to raise funds? Any difference in the financial statement? Can anyone help me? Any of you have an accounting degree, a business degree? I'm sure you know more than I have. Even I also have an accounting degree. I forgot, right? I returned the knowledge to the professor. I have a master's degree in accounting, but I forgot everything. But at least I remember one thing. When you look at the financial statement, something we call the balance sheet, right? Balance sheet is not about the sheet. Balance sheet is a sheet, it means a piece of paper, right? To illustrate the asset of the company, right? To illustrate the asset of the company. So when you look at the financial statement, the balance sheet, when you make a loan, when you borrow $1 million, so that's a loan, and that's a debt, right? A debt. Payable, you have to pay back. So normally, that's not a good thing. Normally, right? Not absolutely, because it depends. Right? Depends on how you use the money. When you borrow the money, you can use it for further investment. When you have good return, then that may be a good thing. But normally, right? Normally, when you are heavily in debt, that's not a good thing. So think about a person, right? Think about a human being. When you're heavily in debt, normally you are not in a really good financial situation. And you look at the financial statement. When a company issue shares to raise funds, right? Also $1 million. But what being illustrated in the balance sheet is only shares capital, right? It means the company, on the one hand, get $1 million by borrowing, or the another hand, get $1 million by issuing shares capital. With the left hand, that will become a debt. It's not looking so good in the financial statement. But if I issue shares, then that will only be shares capital, and that's not loan. But the cash is the same, right? Cash is the cash, the same. So the company can still use it. So that's an advantage for the company. And only a company can do it, right? It means having a lot of cash, but without creating a debt. Because you don't have to pay back, all right? You don't have to pay back. Remember, you don't have to pay back until the day when you would not, right? In the winding process. So if you know accounting, you know that we have assumption for what? For continuous operating. That's assumption in accounting. That we assume the company will always be operating. But how about the disadvantage? When we have shares being issued, think about the structure of the company. Right? When you issue shares, I'm sure that there will be a kind of impact to the ownership and to the structure of the company, which is unavoidable. Unavoidable. Why? For example, right? For example, this is a company, right? Hong Kong Space Limited. 4 shares being issued by this company. 1 to you, 1 to you, 1 to you, and 1 to you. So only 4 shares being issued. When this company wants to raise further funds, raise further shares capital by issuing more shares, right? Number 1, the company can issue shares to me as a new investor, as a new shareholder. So it means that the original ownership, the structure, will be different, because there will be 1 new shareholder, right? Or the company issues shares to one of them or some of them, right? But anyway, it's still unavoidable. The structures regarding the ownership will become different. Well, I'm not saying that it must be a bad thing, right? I'm not saying it must be, because it depends, right? When you have a new shareholder, when you have a new investor, I'm not saying that it is absolutely bad, but that may be a problem, right? That may be a problem. So that can be considered as a disadvantage, right? Not absolutely, right? Not absolutely, but maybe, right? Maybe. But when you borrow money, you don't have such a problem. Your only obligations regarding the loan is for what? To repay on time, right? You repay on time, that will be fine. When you borrow money from the bank, the structure of the company will have no impact. Okay. Then we need to have a very clear concept regarding the issuance of shares. What I mean by issuance of shares? So this is a company here. When the company issues new shares, either to old shareholder or new shareholder, issue new shares either to old shareholder, it means existing shareholder, or new shareholders. A company can only raise funds by doing this, right? The share must be new, right? The share must be new. So don't mix up with another concept. If the share price, right, this company already issued 4 shares. For whatever reason, right, the value of these shares goes up from $10 to $30. It doesn't mean that the company can benefit from it, at least not in terms of cash, right? Because there's only numbers. There's only an accounting concept, right? So the shares capital of this company goes up. But the $20 here, from 10 to 20, right? From 10 to 30, right? The $20 here is only a book value, something we call. Something only exists in the financial statement, right? But that's not cash to the company. The company can only raise cash when the company issue new shares, right? The value of the existing shares will have nothing to do regarding the cash of the company, right? So only the company can only raise funds by issuing new shares, remember, right? New shares. So we look at the first paragraph. So issuance of shares means that shares are acquired by shareholder, existing or new, right? Old shareholder or new shareholder from the company. So that's where the company issues shares directly to the shareholders. So only when you issue new shares to shareholders, and that's the only ways you can raise money from it. Right? You can get cash, right? But not to mix up the value of the existing shares. It's nothing to do regarding the cash of the company, right? That's only a book value, right? It goes up, but that's only a number in the financial statement. It's nothing to do with the cash of this company. The company can only raise cash by issuing new shares, right? But apart from that, something we also need to know. I suppose you understand what I mean by issuance of shares, right? Issuance of shares, it means new shares being issued. But there are some other concepts regarding the movement of shares that you also need to learn about. Number one, transfer of shares, transmission of shares, and subscriptions or initial subscriptions. You know, all these things also involve the movement of shares. But they have nothing to do with raising cash for the company. Number one, what we mean by transfer of shares. What we mean by transfer of shares? Well, you understand what I mean by issue of shares, right? Issue new shares to existing or new shareholders. Then how about transfer of shares? What I mean by transfer of shares? Come on. Maybe there will be another scholarship. And this one will be iPhone, right?
Oh.
Or maybe a new iPad. But don't trust a lawyer, right? Because a lawyer means a liar, right? Pronunciation very similar, right? A liar, a lawyer, a liar, a lawyer. Okay, what I mean by transfer of shares?
The existing shareholder transfer is shared to another one.
Right, you are correct. Absolutely correct, right? Very good answer, Angela. So you deserve the prize here, right? Maybe you deserve another one. What I mean by transfer of shares? When the company, say like, there are two shareholders in the company, right? Shareholder A and shareholder B. When the shares of shareholder A transferred to shareholder B, then we call transfer of shares, right? It means the shares being changing hands of the existing shareholders, right? Then we call transfer of shares, right? Transfer of shares. Or the existing shareholder sell the shares, right, to the new shareholder. Then we also call transfer of shares, right? Changing hands, right, between existing shareholders or to a new shareholder. But the shares not from the company, from existing shareholder to a new shareholder, not from the company. So don't mix up with issue of shares. How about this one? Transmission of shares. Well, that's not a word games, right? 唔係喺度玩文字遊戲。Because they are different. Transfer of shares and transmission of shares, they are different. So I'm not playing a games here. We are not playing a puzzle, right? They're different in law. So I suppose you understand what I mean by transfer of shares, right? But how about transmission of shares? What I mean by transmissions? The process of transferring the shares. The process of transferring the shares. The process. You mean the process? All right. So how we call it in law? We call when shares being transferred by the operation of law.
Procedures.
Then that will be transmission of shares. You still don't understand, right? That is normal. I'll give you an example, then you understand. When grandfather passed away, the grandfather holds some shares in ABC Limited, right? When grandfather passed away and grandson inherited the shares by successions, this process we call it transmission of shares, because that is by the operation of law. They are not buying or selling, right? The grandson is not the one to buy the shares, but inherited the shares, 繼承, right? Inherited the shares by operation of law, right? That's one example. Another example, I have a contract with Simon, right? I signed a contract with Simon. I deliver some goods to Simon, and Simon need to pay me $1 million, right, within 14 days. But he refused to pay, and I sued him in court, and I get a court order, right? I won the case in court. So I get a court order in order to confiscate all of his assets, right, for the $1 million, because he's not having $1 million cash to pay the debt, right, owed to me. Simon is not having enough cash, but Simon owns some shares in ABC Limited, and it also has good value, right? So based on my court order, I can take all the shares from Simon, and then the shares of Simon in ABC Limited will be transmitted to my name, and we also call transmission of shares. Do you get my point? And that's why we call transmission of shares, means by the operation of law, not buy and sell, right? Because of some legal procedure, right? Some legal procedures. or anything legal, right? Legal. The underlying reason is a legal reason, not buy and sell, right? Not buy and sell. Normally, no money being involved, but I have some right to have the shares because of the law, right? Just like the grandson to inherit the shares from the grandfather, or the creditors to have the right to get the shares from the debtor, right? Because of a breach of contract and because of my court order, right? I have the right to take all the shares from Simon, and the name of your shares will be transmitted to me, right? Transmitted to me. So we call transmission of share, right? Last one, initial subscriptions. Well, this one is very simple. Just by the literal meaning, I think you understand. When we first incorporated a company must issue some shares, right? To the founding members. Do you remember the terms founding members? The first member, the first few members, right? 第一個或者頭嗰幾個 members, right? The first member, the first few members. When someone wants to incorporate a company, the company must issue some shares to the founding members. So the founding members pay for the shares, and we call initial subscription, right? So the shares capital born with the company. Born with the company. It means the shares capital already existed on the first day of the incorporation, right? So they are not being issued. Don't mix up, right? Don't mix up. Any shares issued after the first day of incorporation will be regarded as issuance of shares, but not on the first day, right? On the day of the incorporation, you have a date, certificate of incorporation, right? When the shares born with the company, we call initial subscriptions. But anyway, no matter it's a transfer of shares, transmission of shares, or initial subscriptions, the company cannot raise new money, no new asset, no new shares capital, right? But that's only changing hands, right? Transmission, only changing hands. And this one, born with the company. So only shares, new shares, issued by the company after incorporation will be regarded as issuing of shares. And that's the only way that the company really raise funds, all right? So you need to have a very clear concept. Do you think that there will be any limitation regarding the shares capital that can be raised by the company? Yes or no? Yes or no? Any of you still remember something we learned in Lecture 6, right? In Lecture 6, regarding shares capital. Then I told you already. I still remember, right? I told you. In the old days, it means 214, right? 214. And before 214, under the regime of Cap 32, the old company ordinance, when you establish a company, when you set up a company, when you try to incorporate a company, under the old company ordinance, when you think about shares capital, one thing, you have to make a decision on one thing, and that's something we call authorized shares capital. Do you remember that, right? But that's the old day, right? That's the old days. It means that in the old days, before 2014, when you think about the shares capital, the shares capital structures, authorized means the maximum. So when the authorized share capital is stated as $1 million, it means that this company can only raise funds by issuing shares, not more than $1 million. Right? Not more than $1 million. But that's the old days. You have to set a ceiling regarding, how much money you can raise by issuing shares, right? And then you set the power value. Any of you remember power value? Then you know that how many shares you can issue, because there are three variables, right? Authorized share capital. Power value means the value of each share. Then by dividing the authorized share capital with power value, then you know that how many shares you can issue, right? So that's the old day. But under the new company ordinance, we look at the first paragraph. The company can issue any number of shares. subject to the maximum number of restrictions in the articles, if any. That's very important, right? If any. It means that nowadays we don't have such a requirement for authorized share capital. It means that we don't have a ceiling. Nowadays we don't have to set a ceiling here. So you can issue any number of shares you like. So you can issue the shares at any price you like, provided that someone is willing to pay for it, right? If someone is willing to pay for it, you can always issue shares, always, unless there are some restriction in the articles, right? There are some restriction in the articles. The issue of shares normally involve a written contract between the company and the subscribers. Why they always involve a contract? Normally, right? I'm not saying necessarily. Not necessarily. But normally, when company issues shares, the company normally also offer a contract, right? A subscription agreement, something we call subscription agreements, right? To the new investor or to the new shareholder. Why the new shareholder need to agree on something? We learned that in lecture 6. Do you remember the different class of shares? Do you remember the different class of shares? Because you have the right to decide the different class of shares. So normally, the company auditors is silent on it. So it means that you have the freedom in design any kinds or any class of shares you like, right? And the company audience only state that when the shares they are having the same right, then they belong to the same kind, right? That's the only requirement. But how many kinds of shares to issue, and what the rights involved in, that's up to you, provided that it's not against the law, right? So that's up to you. Because the company can issue different kinds of shares, so when you issue the shares to the new shareholder, you have to state that clearly. So normally, it comes with a contract, right? In order to state all the rights. Say like Philips, you are now subscribing the shares as ordinary shares, then that will be your right regarding the ordinary shares, right? You say like you have the right to vote, but you don't have the right to dividends, right? Something like that. So normally you have a contract, all right? Normally. But that's not a requirement in law. Right? That's not a requirement in law. Right? That's not a requirement in company ordinance. But for the sake of clarity, right, to make it clear, normally it comes with a contract. I also remember one thing. For private companies, issuance to the public are being prohibited. And remember, that's one of the requirements regarding the definition of a private company. So I hope that you still remember the definition of a private company. So there are 3 restrictions, remember, right? 50, not more than 50. And then there's be restriction regarding the transfer of shares. And number 3 is private company cannot raise funds from the public, right? So you cannot raise funds from the public. What I mean by public? Say like you cannot post an advertisement in the newspaper, in the internet, on the TV, right? To invite someone, to invite strangers to invest in your company. That's not allowed, right, for a private company. You cannot have a roadshow. Do you know the roadshow? The Ant Group, you know the Ant Group, right, from Japan. They stopped the IPO process, but before that they have the roadshow, right? It means someone to introduce the company to the potential investors, right? We call it a roadshow. And you cannot have a roadshow. But that's a gray area. So always bear in mind, right? Because the definition is not that clear. What I mean by subscription to the public? When you post an advertisement in the newspaper, that will be very obvious, right? When you have an advertisement in the TV, that will be obvious. You're inviting the public. But I hold a seminar here, right? I hold a seminar that I talk about, something else, because I'm a law teacher, right? I'm a lawyer, I'm a law teacher. So I talk about company law, but at the end, I have a private company here, but I think my company is good. So I'm thinking that maybe some of you will be interested to be the shareholder of my company, right? So, okay, so I try to know Angela, right? Angela, okay, I'm Edward. Then we shake hands. So now she's my friend, right? Because there's no definition of friend in company ordinance. So now this is my fact, and I can invite Angela to invest in my company. And I don't think that I violated any rules in the company ordinance. Because that's a gray area, right? That's a gray area. You can take advantage from it, all right? You can take advantage. But just don't make it too obvious, and that will be fine. But you have to be careful because that may trigger criminal offenses, right? If you try to invite public investment in your private company. So for a private company, if a private company want to raise funds from the public, they have to fulfill the requirements in the old company ordinance and the Security and Future Ordinance, the SFO, all right? I hope that you still remember. Over 95% of the law regarding the administration of a company are being covered by the new company ordinance, except for two topics remain in the old company ordinance. Number one is winding up, something we are going to learn about in the last lecture, right? Winding up. Another area is prospectus. What's prospectus? 招股書, a little booklet, right? Containing all the information of the company and the purpose why you want to raise funds. When you want to raise funds from the public, you have to prepare a prospectus, right? When you prepare a prospectus, you have to follow the rules stated under the old company ordinance, right? Old company ordinance, and also the Security and Future Ordinance. This one almost covers everything in the financial market in Hong Kong, right? 應該最後嘅一本 ordinance. You know, it's a very big piece of ordinance here, right? 證券嘅期貨交易條例, right? Security and Future Ordinance. So normally we call it SFO, right? If you work in the financial industry, I'm sure that you heard about it. Maybe you don't understand, right? But you heard about it. You need to have a license, right? If you work as a broker or agent, right? I don't remember all the numbers, right, regarding the license. But I know that you have to get a license when you work in the financial industry when you're offering advice to the general public to invest, right? Or you work as a broker, and you need to have a license. The license being issued under the Security and Future Ordinance, right? Okay, so exactly how you offer the shares, we have to do some math here, right? We have to do some math. When the company offers shares, the company can do it, number one, pro rata offer. What mean by pro rata offer? We can call it, for pro rata offer, we can call it what? Pro rata means one word, proportional, yes, exactly, right? Proportional. 按比例啫, right? 按比例. Proportional, yes, exactly. So pro rata offer means an offer of shares to current shareholders in proportion to the percentage of the existing shareholdings. So sometimes we also call it rights issue. Do you know rights issue in Chinese? 公股, right? 公股, right issue. So what I mean by pro rata offer, it will be something like this. So we have 4 shareholders here in this company, right? In ABC Limited. So we have shareholder A, shareholder B, shareholder C, and shareholder D. At first, each of them hold 25, right? So it means in total, 100, right? 100 shares being issued by this company. And then what I mean by pro rata offer? Pro rata offer means that new shares issued based on the existing shareholding percentage. It means that additional 25 being issued, right? 25, 25, 25. So at the end, the shares turn into 200, right? And now A hold 50, B hold 50, C hold 50, D hold 50. But regarding the number of shares increased, it goes up. But regarding percentage, that is what? Exactly the same. The percentage remains 25% and 25%. And that's what we call as pro rata offer, right? So there will be two conditions, P condition, right? There are two P conditions here. What is it? Number one, right? The first P condition, you only issue shares to existing shareholder, but not to new shareholder. No new shareholder, right? Only to existing shareholders. Number two, you offer the same percentage of shares, right? So at the end, the ownership regarding percentage remain exactly the same, right? And that's what we call pro rata offer. Okay, so what's the implication in law regarding pro rata offer? Well, this is rather simple, right? Simple mathematics. I think that everyone can understand, right? You don't have to be an accountant in order to understand. But how about the implication in law? Remember one thing, the company ordinance does not impose special restrictions on pro rata issue. So it means that the board of directors, they always have the right to do so, right? The rationale behind is that a proportional offer should have no material impact to the company structures. In theory, yes, right? Think about pro rata offer. If you are always offering shares with pro rata offer, then at the end of the exercise, after the issuance of shares, the structures in terms of percentage remain exactly the same, right? It means that ownership remains the same. Even the company is doing it day by day, the ownership still remain 25, right? Always remain 25. If I always issue shares according to their original proportion, right? Always the same. And no approval is needed. It means the board of directors can always do it. But that's a very tricky stuff here. Think about dilution. Do you remember dilution? Right? Hazing, dilutions. Right. Think about the different shareholders here. At the first issuance of shares, I'm fine. Right? Second, fine. Third, no. Why? I don't have cash. Right? Maybe A and B, they are very wealthy. Or only A is very wealthy. Right? He's very wealthy. So he can always subscribe the new shares, but not B and C and D. So if the company always issue new shares, and only A can subscribe all the shares, because the company cannot force them to buy shares. No, you can offer, right? But they have the right to reject. You can give up the right. So sometimes when you invest in a listed company, you have the notification from a listed company, right? You have the notice in saying that you have right issue, right? That will be something like this. Because you have right to subscribe for more shares, but they cannot force you to buy more shares, right? You only have the right to do so, and you can turn down their offer, right? But you have to think about the consequence. When you turn down their offer, what happens? Your shareholding in terms of percentage will drop, right? Descending will fall because of what? Dilution, right? So it means that you think about it, if the company always issue new shares, and only A can afford, right? Only A can afford. Then after 3 or 4 times, the shareholding with the other director, with other shareholders will be diluted, right? Will be diluted. Okay, that's pro rata offer. How about non-pro rata offer? What I mean by non-pro rata offer? If pro rata means proportional, non-pro rata means what? Non-proportional, right? Non-proportional. 非按比例, right? 不按比例. Okay, but actually, what it means for non-proportional? 2 possibilities. Number 1, 呢個冇插. Okay. So we use the same example, ABC Limited again, regarding non-pro rata offer. So number 1, it can be issued to certain parties only. So it means that the company only issues share, but not to everyone, but only to A, B, or A or B, or C or D, or just C, or just A, right? Just one party, or some party, but not everyone, right? number one. Number two, the company issues shares to everyone, but not based on the original percentage of ownership, right? So the company issue 10 shares, 20, 30, and 100, right? That's non-pro rata, non-pro-rata. Just simple mathematics, right? Not difficult to understand. But what's the implication in law? That's our main concern, right? What's the implication in law? Second paragraph. Prior approval from general meeting must be first obtained from the directors in making a non-pro rata offer. It means that an ordinary resolution must be obtained from the general meeting, right? Ordinary resolution. It means that the board of directors, they can do it, right? They can do it, but they need to have the approval from the general meeting first by an ordinary resolution, right? It means more than 50%. So what kind of approval that can be obtained by the company? Two kinds. Number one, we call general mandate. General mandate. What I mean by general mandate? So you hold a meeting, right? If I'm the director, so I hold a meeting. For example, now it's November, right? November 20. For example, the next AGM of the company will be June of 21, right? If I can get all the resolution with a general mandate, general mandate 一般性授權, right? It means authorizing you to do something generally. General mandate, it means that within this period of time, from today and until the next AGM, right? A certain percentage being approved by the general meeting. If that is 20%, it means that, right? It means that within this period of time, the company can issue shares on non-pro rata basis, not more than 20%. If you obtain the general mandate for 50%, it means that within this period of time, the company can issue shares for not more than 50% on non-pro rata basis. That's what we call a general mandate. If you check the notice from a listed company, general mandates always being requested by the board of directors in a listed company because they want to have the right to issue shares, for example, to their employees under the share option scheme, right? Do you know shares option scheme? 認股權計劃, it means for the outstanding staff or to motivate the senior management to work harder, right? So you always have the right to subscribe to shares, say for $10, which is normally a price lower than the market rate. So if the shares of the price go up to 30, and you have the right to buy from the company for $10, then you make a huge profit, right? And that's a way to motivate the senior management to work hard in this company, right? We call share option scheme. If you want to have share option scheme, you need to have the general mandate first. Otherwise, you cannot issue new shares on non-pro rata basis, right? Remember, non-pro rata basis. It means you don't have to issue shares to everyone, just to someone, right? The general mandate. Or you have a special or specific authorization. It means that does not refer to a period of time, but on a particular day only, right? For example, the company can issue shares on 10th of December 21 for not more than 50% of shares on non-pro rata basis, right? So it means that you can only issue shares on non-pro rata basis, not more than 50% on this date only, right? On this date only. So you can do so, but normally this one is not desirable, right? Because if you think about the flexibility, general mandate will be much better because you can do it within a whole period of time, not just on a specific date, right? So normally general mandate will be preferred by the company. Very important, right? 一般性授權, all right? Do you know a person, David Webb? Any of you ever heard about a person, David Webb? He's the one to promote the campaign of corporate governance he was once a banker, right? He retired very early because he made a lot of money from the stock market already. After his retirement, he managed a website, right? A website. You can search David Webb, D-A-V-I-D-W-E-B-B, right? David Webb. 股壇長毛啲人叫做 right? The long hair in the stock market.
Retired now.
Retired now, right? It's only 50, right? Around 50. Right? But he was diagnosed with cancer recently. Right? If you can search his news, right? So David Webb. You know, before my admission as a barrister, I was once working as a company secretary in a listed company, right? In one of the company I worked right for my previous employer. But at that time I was the company secretary, and David Webb, he was one of the substantial shareholder of my previous company. It means he hold more than 5%. But this is a lot of money. The thing about a listed company with more than 5%, there's a lot of money involved. Even there's only a small listed company, right? 幾億嘅應該係。You know, he always want to talk to my boss. My boss is the financial director. Regarding the general mandate of the company. Because he was very sensitive regarding the general mandate. Why? Because when the number is big, it means what? Dilution. Right? The shareholdings of the existing shareholders will be diluted with the numbers in the general mandate being a big number. Right? You think about that. The company can issue a lot of shares to their management. And when there are more shares, it means the existing shareholders, their percentage, their ownership in terms of percentage, dropped, right? So he always like to make a call to my boss, you know, to talk about the general mandate issue, right? But normally I'm the one, right? I'm the one to entertain his complaint or request, right? Because at that time I was employee, right? I take instruction from my boss. So what will be the procedures regarding the issue of shares? I'll remind you once again, when you learn company law, when you study company law, there will be two approaches. One is focusing on the law, the legal principle, and the problematic areas. Another one is to focus on procedure, right? So for the later case, it means you want to be a company secretary. Because when you work as a company secretary, you have to understand all the procedures because you are the one to responsible for, say, like holding a meeting, right? File all the documents. And if you want to be a corporate lawyer, then you have to focus on the legal principle and you know, the problematic area. It just happened that I have dual background because I worked as a company secretary before, then I now working as a corporate lawyer, right? But when you're studying company law, so there will be two different approaches, right? So, and procedures in this module is not the main concern. So normally you don't have a problem, you don't have a question, merely or just on procedure, right? Normally you don't have it. But that's not our main concern, right? But so we just take a quick glance of it. What will be the procedures regarding the issue on shares? Number one, they will not be exempt, I can tell you, right? They will not be exempt. But just take a look. Number one, the directors, first, you have to think about whether you need to have approval for a general meeting. I mean, if you are directors in the board, if you want to issue shares, right? You have to think about whether you need to have approval. And that depends on whether you are offering shares on pro rata or non-pro rata basis. If you offer shares on pro rata basis, you don't have to. Then you have to think about to sign a contract with the new investors, right? Why? Because of the different rights of the shares attached to the different kinds of shares, right? So somehow you have to think about a contract. And remember that the subscriber need to be registered in the record of the company. The subscriber can only be recognized as a member when the registration has been completed. Because, I hope that you still remember, we have the concept of forms and substance, right? Say, when you may have a partnership, you may form a partnership, even you don't call that thing as a partnership, right? You never call it as a partnership. But when in substance, you work as a partnership, then in law, you form the partnership, right? You understand that concept? That's what we call form substance. Because we don't care about the name, we care about what's actually happening. But that's not the case for a member in a company, because we don't have a concept that we call a member in substance, right? No such thing. A company will only recognize a member if you are being registered in their registry, right? If your name is not being registered, then you are not a member, and that's all. If I hold a general meeting here, if I'm the company secretary, so I will stand here at the entrance to check their ID card, and I have a list here, right? Nowadays we use a computer, of course, right? You show me your ID card, I type the ID number or your name, and to see whether you are registered as a member in my company. If you are not, no, you don't have the right to work here. Get out, right? Otherwise, I call security, right? Then I show you. No, you don't have the right to do so. Because only registered member will be recognized. Do you remember nominee shareholder? I explained to you last time, right? Remember the case between Edward and Simon? I don't want my name to be appeared in any public record, but I want to invest in some company. So I transfer the cash to Simon, to his bank account, and Simon, you help me to buy the shares, right? Then in the name of the shares, we registered with the name of Simon. But actually, the shares being owned by Edward, because I'm the one to pay, right? But to the company only recognizes Simon. I don't have any right regarding this company. If the company not recognize nominee shareholders. Do you remember the derived actions, right? Who can, unfair prejudice. Who can apply for unfair prejudice applications? Only registered member, right? Because in company law, only when your name being registered, then you will be recognized as a member. Otherwise, you are not, right? You are not. Last thing, we have to file some forms to the company registry. So after the issuance shares, but that's only a procedure, right? That's only a procedure. So that's the return of allotment and the statement of capital. You have to do it within 1 month, right? But that's only formalities. Okay, so that's all about equity financing. So let's talk about loan financing, right? Let's talk about loan financing. Few more pages before we have the break. So another method of financing that we call loan financing is actually raised fund by what? Borrowing. Right? Yes, borrowing. You just borrow money, right? You make a loan. So you can borrow money normally from the bank, right? Normally from the bank, but not necessarily. Not necessarily. I mean, you can also borrow money from shareholders. Do you remember independent, separate legal entity, right? So the shareholders can lend money to the company. That means the company can borrow money from the shareholders, and something we call the shareholders loan, right? Shareholders loan. It means that when you want to invest in this company, subscribing the shares is not the only way to do so, because the company can borrow money from you, and you are not subscribing any new shares, but just the company borrow money from you. That's a very practical issue. Sometimes, which is preferable. Why? So think of it. This is a very practical issue. You cannot learn on the textbook.
To get better money.
You can get better money.
Yeah.
Yes. But why is better? By comparing with subscribing the shares. You get the money back, right? Because that's a loan. Correct. I think Simon is correct. When you subscribe the shares, normally you cannot ask the money back. Normally, right? Until the day of writing off. Normally you can ask the money back. But when you sign loan agreements, you can get the money back. And one more thing, because that is based on a contract, so you have the right to state the condition as you like. And the company ordinance is almost silent on it, because that's a matter of contract law. So you can always state many different conditions regarding the repayment from the company of your loan, right? You have the right to do so, because that's only a contract. And freedom of contract. You can sign any contract with your own company, with any terms. But when you subscribe shares, you will be restricted by the company ordinance. That will be very difficult for you to get the money back. All right. Okay, so normally you borrow from the bank, but sometimes you borrow from shareholders. So we call borrowing externally or internally, right? But we don't have time, to discuss in great details. So we just suppose that we borrow money from the bank, right? Just suppose that. There are not much restrictions in the company audits regarding the company in making a loan, right? Because somehow that's a matter of contract law. Because a loan normally being based on a contract, and contract being governed by contract law, not company ordinance, right? But there's something we have to pay attention with regarding loan financing. So number one, when company borrow money, a company need to have a document to prove the existence of the loan, right? Well, a verbal contract is valid in contract law. Right? Verbal contract, it means you can make a contract orally, but that's not advisable because that will be very difficult to prove, right? That will be very difficult to prove. Because one day if you want to sue the other parties, you have to think about evidence. If you make your contract orally, so how to prove what being agreed in court, right? So that's possible, but not advisable. So normally don't do it, right? So it means that when a company borrows money from the bank, there will be some kind of document, and we have to learn about it, right? There will be some kind of document. Number two, when a company borrows money, some kind of security must be created in order to secure the loan. Securities, like what? Something like mortgage. Right? It means to make sure that you can pay back. So we have to understand the documents, and we have to understand the securities in loan financing, right? So these two areas will be our focus, all right? The document being used in financing. So roughly speaking, right, there are two documents that may be involved for regarding a loan of a company. So number one, a loan agreements, right? A loan agreement. What's a loan agreement? You can just call it a loan contract, just a contract, right? Substantially, it's a contract. So a loan agreement is a form of contract, and it's a private agreement between the lenders and the borrower. The company ordinance is almost silent, and the operation is somehow being governed by contract law principle rather than company ordinance, right? Because that's all about contract law. When you borrow money from the bank, if you are a company, when you are a big company, or at least a medium-sized company, then you sign a loan agreement with the company. Sorry, you sign a loan agreement with the bank, or something we call the bank facilities. So any of you were in the bank. I think some of you were in the bank, right? Then you understand what I mean. The bank facilities. Special terms in describing a contract signed with a bank, right? We call it bank facilities. So the company law is almost silent regarding the loan agreement here, right? So another document, that will be our focus. This thing is somehow just a contract, right? It's a contract. So you have the right to drop your own terms. The company also is silent, right? It's silent. So that will be different by different companies. So let's focus on another document. And there's a debenture, right? It's a debenture. What's a debenture? What's the name in Chinese of debenture? 债券. Right. Yes, 债券. So what's the debenture? What is it? It's an instrument that can be issued by the company to raise funds. So we call it instrument. We don't call it agreement. Because they are different. Right. So let's take a look at debenture before we have to break. You may want to ask a question. So why I only mention debenture? If you go in the financial industry, or you have strong commercial sense, so I'm sure that you heard about something similar to a debenture. For example, like bond. So what's the name of bond in Chinese? Also, 债券, right? And there may be some other name. So why I only mention debenture here? Because the company ordinance only defines debenture. But debenture actually cover everything. We look at the definitions in the company ordinance. The company ordinance defines debenture as what? Bonds, right? It means debenture also means bonds and any other debt securities of the company. So any instrument issued by the company with a debt in nature will be regarded in company ordinance as debenture, no matter how you name it. Something like the definition of a directors, right? Do you remember directors? You may be regarded as a director under the company ordinance, whether you have the title or not. Because when you hold out as a director, when you work as a director, when you claim yourself to be a director, or when you are controlling the other directors, then you will be regarded in law, in company law, as a director, right? So your name doesn't matter. So that is the same for debentures, right? Because the company ordinance define that if you call it debenture, fine, that's a debenture. If you call it bond, that's a debenture. Or you are not calling that thing as a debenture or bond, if that is a debt security, it means that when you create a debt, if that thing, then that will be regarded as a debenture. So we only have definition of debenture in the company ordinance. So this is the definition in the company ordinance, bond and any other debt security. When you look at the common law definition, then we have a better understanding. Because in common law, debenture has been defined as a document creating or evidencing a debt owned by the company to a person, right? So instrument, it means something pre-printed, right? Pre-printed, already printed with a piece of paper. That will be the same. The company can print 10 pieces, 100 pieces, right? And in law we call instrument. And that thing create a debt owned by the company. It means that when you hold that thing, right? When you hold that thing, it means that the company owes you money. So in plain language, a debenture is a certificate issued by the company to lender to prove the payment obligation. It means that when you hold it, it's an evidence to prove that the company need to pay you back. It means the company borrowed the money from you, right? So the debenture has a face value or the repayment time, or that may be transferable. It means sometimes you can sell it, right? You can sell it to another person. So if I hold debenture here, right? I hold debenture. So this one, with the payment obligation from the bank, from the company, right? So I can sell it to Angela. So if Angela hold this debenture, then the company need to pay you. And you can also sell this debenture to Philip. Then the company need to pay Philip, right? That may be transferable. Depends on the terms inside the debenture, right? This is also transferable. Something like this, right? Something like this. That's why we call it the instrument, because there's a lot of loan agreement. Loan agreement is what? Case by case, being negotiated between two parties. That may be different between the bank and company A, and that may be different between the bank and company B, and that may be different between bank and the company C, right? But for a loan instrument, that will be the same, being issued by the company, right? The company can issue this thing, exactly same content, same looking, for 100 or 1,000, right, to different holders. If you hold it, it means that the company owes you money. The company will pay you according to the terms here, right? Or something like this. The law, the company ordinance, silent regarding the content inside, right? So the format will be subject to your own creations. You can design your own format regarding the debenture, because the point is that provided that you create a debt obligation, then that will be regarded in company law as a debenture, right? As a debenture. So what will be the procedures when you want to issue debentures? Simple. There are only two registration requirements. Number one, you have to register an allotment of debentures in the company registry within 1 month. and that must be in a specific font. And you also need to do registrations in the company registry. And the record must be kept in the registered office where members and debenture holders shall have the right to inspect. So it means that when you issue debentures, there are two things you have to do. Registration, right? One in the common registry and also in your own record. You only need to do registration. Okay, we have a break first, right? So after that, we talk about securities, right?
问一下，你刚说那个 authorized share capital 现在是没有这个概念是吗？
冇呢個概念，點解冇呢個概念？
就是說現在不會再特別強調。
哦，係啊，喺呢個新嘅 company ordinance 裏面咧，已經冇呢個概念，未有，因為係舊嘅 company ordinance 先有 authorized share capital，即係話你要 set 一個 limit，一個 boundary，係啦，ceiling，你講係 ceiling，即係一個最多係個 maximum。就
一次嗎？還是說
開始 incorporate 個 company 嗰時，即係你喺舊 company ordinance 當你開一間公司嗰時，你就要決定呢樣嘢，就話呢間公司最多可以 raise 幾多 capital，即係類似少國內有一個叫註冊資本嘅概念，你有冇知道啊？註冊資本類似少少，唔係完全一樣，類似少少，即係話你要講明你間公司最多可以 raise 幾多 capital 咁，但係而家呢個 requirement 已經冇啦，已經未有。
所以那如果說現在我要 increase share capital 的話
，you can always do so。subject to the pro rata offer 同埋呢個 non pro rata offer 裏面嘅 requirements。
就不會再說我再變更什麼 authorized share，就沒有。
沒有。
謝謝。
好。
上之前上一堂啊，上一堂兩三樓嗰時咁啊，唔係今日嘅。 留喺上面影嗰時，我唔係。你 Michael， 佢認唔到，我淨係掛住望住呢個，我坐前面望到後邊。
我有相㗎。
誒，即係你嗰個 number 你嗰度。哦，咁樣。
我會細粒啲。
其實唔使擺我嗰個簿啊，我擺到度。因為佢出聲啊。
唔係㗎，喺喇叭下面咁好散㗎聲。
係嘛？
勁細聲。喇叭係。
周圍都有嚟㗎。咩？唔係我部手機用手機。咗都冇用嘅，唔會聽。
我有聽。
嚇！有聽。
我有聽嘅，日聽夜聽。
哇！
聽到中毒啊！就係。
哇！3個鐘頭喎。
唔係我分佢聽嘅，我唔會唱。
真係聽係啊！哎呀！
你嘅腦講話係你啊，定係佢嘅？
你可以播快，即係 speed 嗰個幫佢搞快啲，你可以聽得快啲咯。係啊，
又可以食。
有你 play 嗰度可以揀㗎，係啊係啊。佢咁嘅速度咧，如果你翻聽咧，你要1.5啊。係啊，佢本身速度快大劑。即係佢係算係慢嘅講得，咁如果你播翻自己聽咧，你得1.5啊或者就我覺得係聽得唔清嘅。咁呢個點啊？光啊！之前 Martin 嗰啲咧，其實我都有 video 嘅，我都冇睇，我自己 cap 晒 screen 嚟，自己 save 晒嘅。Martin 就 Martin 嘅。唔係，即係佢嗰段 video 有聲㗎嘛，Martin 我哋 zoom 㗎嘛，咁佢 zoom 見咩咪錄咩咯。但係佢唔聽，好成日或者都唔好想聽。你居然聽？好彩 Martin 嗰啲咧，佢冇 delete 到好彩，我都以為 delete 到垃圾啊！我諗我 course 唔到。好細啲睇唔到啊！大一部係啊，動喺度。總之係咁咯，即係咁上下細細支。咁啊，嚟自於費事啦，因為之前話過一次咁啊，喺大陸大方話唔俾落啊嘛。冇啊！我上次影啊，我哋第一堂上去嘅，好似。
Okay, we're back to class. Just remember, before the break, we learned about debenture, right? So remember, once you get a debenture from the company, it means that, for example, this one, when you have this thing here, right, we call it instrument. It means that the company owns you $5 or £5 here, right? And according to the conditions, the company will pay you back within a certain time frame, maybe in 5 years, right, or 10 years, plus the interest rate. So you hold it. It means the payment obligations. It improves the payment obligations, repayment obligation of the company. The company have to pay you back, right? Pay you back, because the company borrowed $5 or £5 from you. Company pay you back within a certain time frame plus the interest, right? And you can also sell this thing to the others. When the others get it, the company pay to another person, right? So that's debenture, right? So that's debenture. No matter how you call it, you can call it debenture, you can call it bond, or some other names. But provided that if you create that obligation, then in company ordinance, it will be regarded as debenture, right? Okay, that's what we learned before the break. So let's talk about security, right? Let's talk about security. What I mean by securities? Well, sometimes we need something to secure a loan in order to ensure the safety of a loan, so the lender can have recourse if the company fails to repay it. So it means that sometimes when a company borrows money, the bank cannot just rely on the loan agreements. That may not be safe, right? That may not be safe. Because there will be a possibility that the company cannot pay back on time. That's not a requirement in the law. That's only a business consideration. That depends on how much money being borrowed by the company, and also depends on the reputation of the company. So if I'm a bank, if Changgang borrow money from me, right, from my bank, or if Alibaba borrow money from a bank, so I don't think that, probably I don't need to have any security at all, because I trust the good reputation of this company. I trust that they are going to pay me back on time. So that's not always being required. That's not a requirement in law to have security, right? But that may be required if we are talking about a small company or medium-sized company, a company not being well known. So if you want to borrow from the bank, just sign a loan agreement is not enough, because of what? You have to remember the principle of separate legal entity, right? When your company is not having a lot of asset, even your company sign a loan agreement with the bank, and when your company is not capable to pay back on time, the bank can only sue the company, but not you, right? But your company is not having substantial asset, so it means that that loan agreement itself cannot offer sufficient protection to the bank, right? So sometimes the bank need to think about security, right? Something in addition to the loan agreement to secure the loan. So it means that if something wrong, if you're not paying on time, so something else I can do, right? Something else I can do. So there are two main kinds of security that can be offered by the company. So number one, we can think about personal security, or sometimes we call personal guarantee. Sometimes that will be requested by the bank. For example, when you use a shelf company, it means the company is not having real operations, or company is not having substantial asset, but you still insist on using the name of the company to sign a contract or to borrow money from the bank, right? Probably you can do so, but the bank requests the shareholders or the directors of the company to sign a separate agreement to guarantee the loan on their personal capacity. So it means that, right, as a guarantor, 担保人, right, as guarantor. It means that there will be a condition in saying if the company is not capable to pay the debt, on time, right? Not on time, not in full. Then as a guarantor, you have the right, you have the obligation to pay for the company. And that's what we call as a personal guarantee. So normally the directors or the major shareholders will be the one considered by the court, considered by the bank as a suitable person, right, in offering personal guarantee. Of course, they don't like it. Of course, they don't like it because personal guarantee means personally you will be liable for the debt of the company because of the separate legal entity. Normally, the debt of the company, the liability of the company will not be your own problem, right? You will be protected by the corporate form. But if you sign a personal guarantee, it means that the bank can sue you for the payment for the company. But remember, it's something we call secondary obligation. The bank can only sue the guarantor if the company failed to pay on time. So you have to prove it first, right? And it depends on the conditions of your personal guarantee, what being cited, right? But anyway, that's one way as a security requested by the company. Requested by the bank. Well, actually, there's another one. But I consider that to be very similar to personal guarantee, and there's something we call corporate guarantee. Do you understand what I mean by corporate guarantee? Make a guess. You can understand. You think about that. If you were the listed group, or if you were the enterprise, right? Normally there will be a change of company. So you are having the holding company here, right? The holding, or the mother group, right? Or the mother. And then under the mother group, there will be many subsidiaries. Subsidiary 1, subsidiary 2, subsidiary 3. Sometimes a subsidiary being established to do one thing only, right? Project-based. So sometimes we call them special purpose vehicle. SPV. The name, always like to be used by the U.S. attorney. Not common in Hong Kong, right? But the American lawyer, he likes to use SPV, special purpose vehicle. It means you set up this company to do one thing only. Right? Okay. But you know that because of the concept of separate legal entity, if you set up a subsidiary fee to sign a contract with a bank, right, or someone else, if anything wrong with this subsidiary, the mother group will be fine because of the concept of separate legal entity. You cannot sue the holding, right? You cannot sue the mother. So if anything wrong, because there are no substantial asset in this subsidiary, so the holding company don't really care. If you want to sue a subsidiary, please do it, right? Please do so. I don't care, right? I don't care because this company is only a shell. Right? It's only a shell. I mean, no real operation. If you want to sue, you just sue, right? You sue. So you still insist on using this company to borrow money from bank or to sign a contract. So sometimes bank want the holding company to sign a corporate guarantee, right? So it means that if your subsidiary cannot repay on time, then the holding company have to be responsible for the debt. So I mean, in substance, something like personal guarantee, right? Something like personal guarantee means that when you cannot trust a shell company, then you need another person to guarantee the payment or the obligation, right? So that person can be a real person, a human being, a director or major shareholder, or that can be the holding company, right? We call corporate guarantee. If you have the experience to work in the company's secretarial department, then you understand what it means, right? Corporate guarantee. Or sometimes there will be some other conditions, right? For example, the bank can sign loan agreements without asking for personal guarantee, without asking for corporate guarantee, but they impose a condition saying that someone must be the major shareholder of this company, or someone must be the director of this company. If that person resided or quit, then you have to pay the money immediately. You have to pay back the money. Call them, right? Call them. So you have to pay immediately. For example, because you only trust Jack Ma, right? Because you only trust Jack Ma. I only trust Mr. Ma. So when Jack Ma is the major shareholder of this company, I'm willing to sign a loan agreement at the bank, right? I'm willing to sign a loan agreement with this company, even without any guarantee. Even with this company, it's only a sell company, because I trust Mr. Ma. But if Mr. Ma is no longer a major shareholder, or if Mr. Ma is no longer in control of the board, then you have to pay back the money immediately, right? So something like this. That can be one of the conditions stated in the loan agreement. But that's not exactly a personal guarantee. Not exactly a personal guarantee, but similar, right? It means because you only trust a particular person, right? So you can do so. So when you think about secured loan, you can think about personal guarantee, right? But of course, most companies will be very unwilling to do so because it means that you will be personally liable, right? You think of it. When you're running a business, what will be your concern? What will be your main concern? Just two things. Number one, profit. Another one, liability, right? Nothing else. Without any moral consideration, right? You don't care, right? Because I'm not running a charity. When you're running a business, you concern about profit and liability, and that's all. So when you sign personal guarantee, it means that you will be personally liable for the debt. People will be very reluctant to do so, right? Very reluctant. So apart from personal guarantee, what can you do? We can create a security over the company asset, right? We can impose some legal obligation on some of the asset of the company. For example, this computer belongs to Hong Kong New Space Limited. Hong Kong New Space Limited signed a loan agreement with me. I'm a bank, right? So in order to make sure that the company can pay back, I try to create something on this computer. So in case the company cannot pay me back, then I can get the computer, can take the computer. That's what we call as a security created on something, right? So in law, we call real security. Okay, so how to do it? So how to secure the asset in order to protect your interests? What can you do? The simplest way is to ensure security is by physical possession of an asset. If that's in the old days, you think about a very simple market structure, right? A very simple economy in a village, in a small town, when people are running business and doing business. If they want to make sure that, when you borrow money from me and you pay back, right? What you do? You don't have to think about all the documentation. Right? You don't have to, because you can just simply have physical possession of something with value. Right? That's simple. I borrow money from Simon, right? So Simon is a bank. I'm a company. In a very simple economy. So how to make sure that I pay back? Then Simon asks, well, do you have anything valuable? Oh, okay, you get my watch, right? Okay, you get my Rolex, you get it.
No guarantee.
All right. So the watch now belongs to Simon. If I pay back on time, I can take it back, right? If I don't, so you can have my watch. So simple, right? So physical possessions on something valuable, that can resolve the problem, and that's a very simple kind of security, all right? But think about that. Nowadays, is it possible? I'm not saying impossible. You can still do it. You have some gold coins, right? You have some diamonds. You can try to negotiate with the bank. I want to borrow $5 million, and I have some diamonds here, right? You can keep it for physical possessions. After I pay back all of that, then return the diamonds to me, the gold coins to me, or your very expensive watches to me, right? Possible, but not really sensible, right? You think about nowadays, with very complicated transactions, numerous transactions, that will be very troublesome for physical possession of the asset, right? And sometimes that will be very difficult to have physical possession of the asset. For example, there's a big machinery, right? I don't have a warehouse to keep it. So physical possession is not really sensible. You can do it, right? You can do it. Yes. Still possible, why not, right? Why not? You can try. There are some financial institutions, 有啲財務公司 you can actually use your watch. They keep physical possession, and you can borrow money, right? That's real. You know, for some famous brand, right? Rolex, Patek Philippe, right? Very famous, you know that big names, or you really have some gold coins on Gumtiel, right? They're willing to keep it and to pay you the cash, right? Real. I'm serious, right? There's some financial institution, small one, right? They're willing to keep, or even the handbag, a very expensive handbag, Hermes, right? Gucci. I'm serious, right? But of course, not a big sum of money. Maybe 20,000, 30,000, right? Not a big sum of money, but they're willing to do so, right? Because when they're certain that your watch is, you know, far over the money you borrow from them, and if your watch is a real one, right? Then they are willing to do so. But normally that will not involve a big sum of money, right? That will not involve a big sum of money. So it means that physical possession is not really sensible nowadays. You can do so, but not really sensible. Then what can we do? We have a legal approach to create non-possessory security. So it means that we create security on the asset of the company without having physical possession, right? We don't have to take it, but we can still create some rights on it that we call non-possessory securities. So how to do it? There are two different ways. Number one, you can actually transfer the legal title of that asset to you, and then you sign a contract with the bank. After you pay all the money, then I will return back that asset to you. For example, right? So there's a piece of land. So you actually transferred that title, the title of that piece of land to me. So I own that piece of land, right? But I sign an agreement to you. I sign a contract. If one day you pay all the money, I transfer it back to you. But that involves the transfer of the legal title of that asset, right? Whether that is suitable depends on what kind of asset you're referring to. But we have another way, which is, you know, far more simple. We can create a proprietary claim on certain asset in case of default of payment. It means that I don't want you to transfer the title to me. You can still keep the title, the legal title. So I'm not claiming for physical possession, right? Not physical possession. 我唔會攞你走嘅。I don't even ask for the transfer of title, but I want to create some claims on something in your company. So in case you cannot pay me on time, then I have the right to take it, right? And that thing we call a charge, right? A charge. If you ask for the transfer of title, then normally that will be called as a mortgage, right? A mortgage. So I don't have time to explain in details because that belongs to another area of law, property law, right? One day you proceed to the advanced diploma, then you are going to learn about property law. Then you understand what I mean by mortgage, right? Legal charge, all this stuff. I don't have time to explain on details, right? But let's focus on the second one. You create a proprietary claims or claims on some asset of the company, and we call it a charge or legal charge, right? In Chinese, the name is very ugly. I don't like the name in Chinese. Do you know the legal charge, the name of legal charge in Chinese? Anyone know?
備註啊，壓機啊。
Okay. Very ugly name, right? I don't know. But it doesn't matter if you don't know Chinese, right? It doesn't matter. In Chinese we call ugly, right? I don't know. I don't like this name. But anyway, when you want to create a claim on something, on some of the asset of the company, in case the company cannot pay you back, then we call that thing, right? That thing is a legal charge, right? A legal charge, gate. So what is it? So there are two different kinds of charges that we can create: a fixed charge and a floating charge. Regarding the asset of the company, remember, right? You create a charge on the asset of the company. So first one. So the first one, the fixed charge. A fixed charge is a charge over an ascertained and definite asset. See, it may be anything tangible, like land, machinery, or even intangible asset, like copyright or patents. Right? Because when you register a patent, do you know what's a patent, right? 嗰啲知識產權嗰啲 right? Copyright and patents. Because when you register your copyright, when you register a patent, you get the patent number. So that can be identified, right? That means you can identify. And the patent or the copyright can be very expensive. Say, for example, the drugs, right? You know, the new vaccine recently being announced by, is it Germany, right? By Germany. By a German company, I don't remember the name of that company, right? So if you register the patent, it means that only your company can make that drugs, and you can make a lot of money from it, right? So patent can be something valuable. So what is a fixed charge? It means that something specific that you can identify. For example, the company owns a car, right? The company owns a car, which is a BMW. BMW, which is a 7 Series. And with the car number, being number 123. And then I create a charge on it, a fixed charge. It means this car, right, which I can identify, which one exactly, right, which one I refer to. Under a fixed charge, it means that when a company cannot repay the money on time, or the company cannot repay at all, then I have the right to claim on this car. Means I can take it, right? No longer belong to the company, but belong to the bank, right? I have the right to take it. But if nothing wrong happens, let's say if the company is paying money on time, right? Nothing wrong, then you don't have to transfer this car to me first, right? You don't have to. And I don't need to have physical possession of this car. The company can keep using it. But the only requirement is you cannot sell it without my approval, right? That means the company can keep using it, right? Can use it. I don't claim the title. I don't claim physical possession. The company can still use it, but just one condition: you cannot sell it without my approval, right? And that's what we call as fixed charge, all right? Fixed charge. Understand? All right? Specific, exactly which one, what is it exactly? You can identify, right? That will be very certain. Okay. But apart from a fixed charge, we have something we call a floating charge. So what's a floating charge? A floating charge being granted over circulating asset. So something that cannot be identified. So normally it refers to the company stock in trade, right? Company stock. So it means the charge will be created on a class, on an item, on an asset, on some asset only. The company can sue, can use, or even to sell it without the prior approval from the company, from the bank. So if this is a fixed charge, a charge created on a car, you know which one exactly, because you have the car number here, right? You know which one I'm referring to. But what I mean by floating charge? What's a floating charge? Floating charge not being created on a car, on a specific car, but created on a car. A BMW, right, maybe. For example, if this company is BMW, right, so the company, they're having a lot of BMW. So it means that out of the whole stock, can tell the difference between the two. For a fixed charge, right, the charge being created on the particular car, a car that you can point it out, a specific one, right? You know, okay, that one, right? This one, number 123, right? The 7 Series, I know this one, all right? Exactly. But for a floating charge, the charge not being created on any specific car, we only create a foreign charge on a car out of the whole stock. So you don't know which one you are referring to, right? It means that if the company is not paying money on time, then you have the right to claim for one BMW out of the whole stock. But before you enforce your right, you don't know which one here belong to you. You get my point here, right? So fixed charge, it means from the very beginning, you know which one you are referring to, right? Which car you are referring to. But for foreign charge, you don't know. You only know that you have the right to claim for one BMW over the whole stock, but you don't know which one until the day you try to enforce your right, right? And this one we call foreign charge, 浮動壓記，呢個叫做固定壓記， right? Just remember the name in English will be fine, right? So fixed charge, something that can be identified. Foreign charge, you don't. So in a foreign charge, the company, they even have the right to sell the stock here, right? No prior approval will be needed, provided that the whole stock here have at least one car remain. Then the company can handle all the stock here. At least the company need to make sure that at least there's one car, right? One car that will be available for the bank to claim for it if something wrong. Then the company is not betraying any time soon, right? But for a fixed charge, you cannot sell it. You can use it, but you cannot sell it, right? Understand the difference here? So let's try to take the definition from the court case, right? The court defined foreign charge here. So it is a charge on a class of asset. Take a look here, right? On a class of asset, not on a particular asset, right? Not on a particular asset, the whole class of asset. Number two, the class of assets is one, which in the ordinary course of business will be changing from time to time. You only have the right to claim one car out of the whole stock, but you don't know which one. So the stock here, they are circulating, right? We call circulating stock, right? You get that concept? If you understand auditing, then probably you understand what I mean. They are circulating stock. Until some further step being taken by the chargee, it means the bank. The company may dispose the asset. It means the company can sell any asset. All of the whole stock here, provided that at least there's one remain, and that will be fine, right? So the court defined the meaning of foreign charge very well from the judgment here, all right? Do you understand? Can you follow? Right? Can you follow? Okay. All right. Which one do you like? Do you like foreign charge or fixed charge? What's the magic answer?
It depends.
Right, it depends. Right? Oh, yeah, I like your son. Right? You also learn the tone of the voice. It depends. You pretend to be, very confident, right? So you can mislead your client. It always depends, right?
Liar.
Yeah, liars. A lawyer is a liar, right? Okay. It depends. Right? It really depends. Why it depends? It depends on your perspective. It depends on who you are. When I ask you a question, which one is good, right? It depends on who you are. Because from the perspective of the company, when you're a company, which one you like? Of course, I think you prefer the foreign charge. Because you are having, what? A much better flexibility, right? Flexibility in dealing with your asset. Because a foreign charge only create a claim on something from the whole stock. And you have the right to handle the whole stock here, including selling the circulating asset, provided that there's one remain, right? One remain. So if you are a company, I think that you prefer a foreign charge, right? That would be better. That would be easier, less burdensome to you as a company, right? So you give a company a high degree of flexibility. But how about for a creditor? You're a creditor, if you are a bank, which one you like? I think you prefer, obviously, the fixed charge, right? Why? Two reasons. Number one, the company may dispose the charged asset without the prior approval from the creditor. If you only have foreign charge, you don't know which car actually belongs to you because they have the right to sell from the stock. And remember that even I have the right to claim for one car, maybe the quality is different, right? Some cars in a better condition, some cars not that in a good condition. So if I can only claim for it when I enforce the agreement. So probably the good one already being sold, and I can claim for the one with inferior quality, right? But if you have a fixed charge, you already know that which one belongs to you, right? Number two, a foreign charge only created over a class or an item, so the exact value of the asset under the charge may change and cannot be ascertained. You don't know, right? Because the stock are circulating. So sometimes you claim one car from 100 cars, and you will be safe, right? Because you only claim one over 100. That will be quite easy for the company to satisfy your demand. Do you get my point here, right? Because the company is having 100 BMW, you only claim for one. But think about that, because they are circulating. So if the companies only have 2 cars, right, and you want to claim for one, it means you are claiming for 50% of the car belong to the company, and that will be, you are at risk to do so, right? Your security is not, it's not that, sufficient to cover your risk, but you don't have control. Because provided that the company can give you a claim for one car, the company is still 100% complying with your obligations, because you only have the right to claim for one, right? But the base, you have no control of the base. So you claim for 1 out of 2, very risky. If you claim for 1 out of 1,000, that'd be fine, but you don't have control, right? So normally a fixed charge will be better because you perfectly understand which one belongs to you, and the company cannot sell it, right? So which one is better depends on your positions. Then you may want to ask one question: how to enforce a foreign charge? Well, you obviously you understand how to enforce a fixed charge because you already know which one belongs to you. If you want to claim for this BMW, right? You know that this one, BMW, the 7 Series, car number 1 to 3, right? So you know that which one belongs to you. So if the company is not paying on time, then you enforce your right and then you claim for it. This one exactly. Then how to claim foreign charge? Because a foreign charge is only a charge. It's only a claim over the whole stock. Then how can I know which one belongs to me? It means that obviously you have to do something more before you can actually take your asset, right? Because you don't know which one belongs to you. Am I correct? Unlike a fixed charge. In fixed charge, you know it, right? You already learned about it, which one belongs to you. But you don't know which one belongs to you when you only have foreign charge. So you have to do something we call crystallization. It's a process to do. A foreign charge needs to be crystallized before it can be fully enforced. And the process we call crystallization. A very beautiful name. You think about the crystal. What's the nature of a crystal? Precious stone, right? We call it precious stones. So which is solid, rock solid, right? 好堅固係咪？ solid like a diamond, right? It's very solid. So what I mean by crystallization? Something like to make it solid, right? Because a floating is just like a cloud. Floating. You don't know where this cloud will be attached to, right? Because you don't know which one. So all of your clouds, right? This is the chart. Floating over all of you, but don't know which one until the day you want to enforce it, right? Then you try to solid, make it solid, and you attach on something, right? So the process we call crystallization, right? To make it solid. Think about the nature of a crystal, right? Something solid. So upon crystallization, the foreign charge turns into a fixed charge. Very important concept. At that moment, right? At that moment, when you enforce it, you try to enforce it, right? And you are telling the company, I want, okay, this one, right? I want this car, right? Or this one, I want this thing. So now your foreign charge turned into a fixed charge. Why turn to fixed charge? Because now you understand which one exactly belongs to you, right? So it turned into a fixed charge, right? So it means that when you want to enforce a foreign charge, the only way to do so is to turn your foreign charge into a fixed charge, right? Only when you turn into a fixed charge, you can really enforce it. Otherwise, you don't know which one belongs to you. That's only a concept. So under what kind of circumstances crystallization occurs? Something based on the loan agreement you signed with the company, right? For example, a very typical one will be default of payment. You promised that you borrow $1 million from a bank, then you have to pay 50,000 at the last day of every single month, right? So now it's 31, and that's the end of this month. So I'm not having the payment, right? It means there's a default of payment. You're not paying on time. Then I have the right to claim, right? So it triggers, right? Triggers, you know it triggers. 觸發咗佢, right? Triggers. So it triggers the foreign charge, and the foreign charge will attach on something and become a fixed charge, right? Apart from default payment, there may be something else. For example, if the company try to wire, right? If you want to wire, it means you want to kill your company, then of course I have to protect my right, right? Or when the company is being sued by someone else, right? Because when the company is being sued by someone else, the asset may be confiscated by the court over. So I have to protect my interests, right? So it may also trigger the foreign charge to be attached and become a fixed one, right? What you need to do when you create a fixed charge, when you create a charge, no matter if it's fixed or not, what you need to do, the company, they always like registration, right? Registration. So the charge created by the company must be registered in the company registry. Must, right? You have to do it. So the purpose of registration is for potential creditors to understand the creditability of the company and to understand whether the company are being heavily in debt, right? That's the purpose, to let the outsider to understand this company. Because when the charge being created on this company, what it means, what it implies for, it means the company is in debt. But normally, only when a company is in debt, then the charge will be created. So when the company is being fully charged, right, almost on everything, it means the company is heavily in debt. Right? 即係你 you can't find more asset to create new charge. Right? 即係咩啊 ？In Cantonese 冇差用。Right? 即係你 you cannot find a new charge. You cannot find any new asset to create a new charge. Right? 即係冇差用。Right? Okay. When there are a lot of charges being created, it means that your company is heavily in debt. So you have to be careful, means when you're outsider, right? And that's the purpose in having registrations. So you have to do it within 1 month, right? Within 1 month after the creations of the charge, no matter the fixed charge or foreign charge, right? You have to register. So who is having the obligation to do the registration? The primary obligations is on the company itself, right? It's on the company itself. It means normally the directors or the company secretary, so they have to do the registrations when a charge being created on the company, right? But the creditors, it means the chargee may also register the charge. Maybe I'm the bank. I created a charge on this company. I signed all the documents. I also lended you the money, right? So I keep checking the company registry. But after a whole month, the company is doing nothing. Because I'm the lender, I'm concerned about our rights. I can also do the registrations for the company, right? So normally for the company itself, but the bank can also do it. What you need to register in the company registry, very important. Listen carefully. It means something later. Number one, you have to register a statement of particulars. Well, actually, that's only a form, right? That's only a form. This one, right? N1. So you can take a look if you like it, but not very important, right? Because we are not concerned on procedure. That's only the work of the company secretary. We are studying company law, but just take a look, right, if you want to. So when you do the registrations, you have to fill in the form. But one more thing, that means a lot. And there's a certified copy of the instrument. It means you have a document actually being signed between the bank and the company, right? Not just the form. The form is just a form. You fill in the information, but when you borrow money from the bank, you have something signed with the bank. And that thing also needs to be filed to the company registry by way of a certified copy. It means that you make a copy, a scanned copy, upload to the common registry, right? But that must be certified. Certified by who? Certified by solicitor, certified by the auditor. Either one, right? Either one. Or the directors. The director can also certify that instrument, right? So if there is there's something wrong with it, then that will be a criminal offense. Forgery. Right? That's a criminal offense. Very serious. So you have to file a certified copy. And this thing means something. I'll tell you later, right? In the comment pages, but very in mind first. So that's the form. Okay, what will be the consequence? Because as a corporate lawyer, as a commercial lawyer, there's always in my mind, because I'm not a human rights fighter, I can tell you. I'm not a human rights lawyer. So if your human rights are being infringed by anyone, don't find me. I'm not really interested. I'd like to help the businessmen to fight for their right, the corporate right, right? Because I'm a corporate lawyer. Bad person, right? Basically. But honest, right? Honest. Because I make it clear that I like money. So what will be the consequence when you fail to do restorations? Number one, you'll be subject to a penalty, level 5. Do you remember where you can find the meaning of level 5? You can find from criminal procedure ordinance. You can find in the index, the appendix in the criminal procedure ordinance. Then you stated, what mean for level 5, level 2, or level 6, right? Okay, when you fail to do registrations, then you have to pay a penalty, $5,000. So who need to pay a penalty? Normally, as I told you, the directors or the company secretary, right? But that is not the most serious thing. Not really serious. So think about $5,000. Is it a lot of money? It depends, right? Come on, it depends. It depends, right? It depends on the size of a company. If there's only a small company in selling the small egg balls, right? In selling pancakes, $5,000 may be quite substantial, right? It depends on the size of your transaction. But for a medium-sized company, for a big company, well, that's almost negligible, right? And that's only money. So I will not get into jail, I don't care, right? Right? This big sum of money, I don't care. I'm a director of the company. So that's not the most serious consequence. But something far more serious. Because when you fail to do the registration, what will happen? The charge shall be void against the liquidator and other creditors of the company who has a claim in the same asset with proper registrations. So I highlight in red. And that's far more serious. Not to the bank, maybe not to the company, but to the bank. Because when you fail to do the registration, listen carefully, right? When you fail to do the registrations, your charge will be void. I mean, that's useless, right? Against who? Against, number one, liquidator. Who's the liquidator? Liquidator is the one to take care of the winding up process. When the company is being wired, right? You're going to learn about this person in the last lecture. So think about that, that will be very serious. Because when the company is in the winding up process, you as a creditor, you have a very serious concern with your right, because the company is dying, right? So you have a serious concern regarding your right, whether your right can be protected. And the liquidator is the one to control the company in the winding up process. But your charge will be void against the liquidator. It means the liquidator can ignore your charge. So that will be very serious. It means that probably, when the company is in the winding up process, you fail to claim for anything because you fail to register. your charge, number one. And your charge also being void against another creditor who have a claim on the same asset, but with proper registration. So if I want to claim for this telephone from the company, right? This belongs to Hongyu Space Limited. So I claim for it. Simon also claimed for it. Simon is a creditor. I'm also one of the creditors. But I failed to register. But Simon properly registered. My claim on this claim will be void against Simon. Right? It means he enjoyed priority because I failed to register. So if you fail to register, the consequence will be what? Serious, right? Not because of the penalty, but because of the right. Because the charge will be void, right? But remember, there are always what? Exception. Yes. Yes. Except for it depends. Right? You also need to learn to think like a lawyer, right? So everything depends. Number two is there are always exceptions. Right? Always exceptions. There are exceptions. I mean that principally that is correct. When you fail to register, your charge created maybe void. That's correct, right? Absolutely correct. But not 100% void. Sometimes still valid. I'll give you two examples here. Number one, the creditor of an unregistered charge can compete with another unregistered creditor on the same asset. I want to claim for this phone. Simon want to claim for this phone. But Simon properly registered his charge. So he has priority, right? I lose. But if I'm not competing with Simon, I'm competing with Angela, right? Angela, you want the phone, I also want the phone. You're a creditor, I'm a creditor. You want to claim this from Hongyu Space Limited, but both of us fail to register. 即係兩個都冇 register, and the charge is valid, right? It means I'm not losing my right to compete with you. We follow some other rules in order to determine who can get it. But anyway, my claim is still valid because another person who claimed for it also without registration, right? So when you fail to register, it's not void absolutely. Right? It void, right? You are in danger. You are in trouble, but not absolutely. Because if you find another person also being stupid, fail to register, and there are only two stupid guys who claim for it, you still fine, right? Because another guy also without registration. Number two, if there are no other registered charge, over asset, then the creditor can still enforce the unregistered charge against the company, even without registrations. So it's not necessarily void against the company. Remember, when you fail to do the registration, that may be void against other creditor, but not being void against the company. Because your relationship with the company, I mean, I'm a creditor, right? I'm the bank. My relationship with the company is not relying on registration. Registration, I explained to you already, is a mechanism to alert the third party that the company is in debt, right? But the registration is not to validate the loan agreement. I signed a loan agreement with this company, and I created a charge on the phone. That's valid against the company, even without registration, right? This charge will be void only against another creditor who registered. Then I'm losing the priority with Angela because he registered his charge on this thing. But my relationship just with the company, if no one is competing for this asset, right? That's possible, right? No one is competing for it, and I fail to register. I only need to face the penalty, but my right against the company is still perfectly valid, right? So remember, when you fail to do registration, you may be in trouble, but not absolutely hopeless, right? You still have hope, right? You still have hope. You can have some leeway, right? You can still claim for something, possibly. Is it possible to extend the time? It means that what I mean by extension of time means that sometimes you fail to do the registration, right? Then suppose your registration, your charge will be void, right? You have to do it within 1 month. So you fail to do it. If you try to do it 2 months later, preliminary, your registration will be void. It means useless, right? You do it 2 months later, your registration is void, right? It offers no protection to you, unless you can ask for extension of time. If you can ask for extension of time, then even you already exceeded the time limit, but your registration is still valid. Valid in the sense that the law regards that you are still doing the registration on time, even you actually already exceeded the deadline, right? The law presumes that you are doing it on time. If you can ask for extension. So make a guess. Who has such authority to extend the time of registrations? There's only one organ, and that is the court, right? Only by the court. So the court may, on the application by the company, on any person interested in the charge, to order that the registration time be extended, right? But I can tell you that will be extremely difficult. Extremely difficult. Where normally the court will not, let you do it, because when you fail to do so, you have to bear the consequence, right? Because you are negligent, you're careless. But sometimes that may be possible, especially when that is not creating any prejudice to the others, right? And that is only out of accident. I'll give you one real example that I succeeded. I succeeded only one in my whole career life as a corporate lawyer, right? Because there are two preconditions here. Number one, the court believed that it was an accident because the company at that time was moving office and all their documents being, messed up, right? So they missed something, right? They missed something, and because their company just laid off a lot of staff, so the staff in the company secretariat department all being fired, right? As well as the accounting department. So there's something wrong regarding the record, and the court believed that it was only accident. Also, at that time, no other charges being created, right? It means that it will not prejudice any other creditors, because there's only one charge being created, no other bank created charge, right? So no one will be harmed. In that scenario, the court granted the order for extension of time. It means the company can do the registration, even already breached the deadline, but that registration is still valid, right? Because of the court order. The court also have just and equitable ground means discretion, right? Except for that, the court enjoy, absolute discretion. So any reason you can think of, you can persuade the judge. The judge can grant you the order, right? But normally, you can only get it because of the two conditions here. Number one, which is accidental, and number two, no one being prejudiced, right? No one being suffered from it. And that thing about the example I used. Okay, this thing, serious and quite complicated. You have to listen carefully. Priority of charges, before we end the class. Just a few more pages, but very complicated. Priority of charges. What is it? The issue of priority may arise when there are more than one charge competing over the same property, right? I created a charge on it, but no one competing for this telephone. I don't think we have to think about priority, right? Because I'm the only one to claim for it. But the problem is when there are more than one creditors who try to claim for this telephone, right? This thing, then we have to think about the priority. Who can have it, right? Who can have it? Because you think about it, there are different kinds of charges, especially for floating charge, right? Sometimes fixed charge, sometimes floating charge. Floating charge means that actually you don't know which one belongs to you until the day you try to enforce your right. So things may be mixed up because there may be two creditors try to claim for the same thing. Because this one is with the best quality, right? So all the creditors want this one, not this one, right? Because this one is better. So they are competing. So when there are different creditors competing for it, then we have to think about priority. What are the rules to determine the priority, right? You have to understand. So priority is actually determined by two factors. Listen carefully. Number one, the date when the charge was created. Number one. right? When the charge being created, number one. Number two, the nature of the charge. What kind of charge being created? Number one is time. Number two, nature, right? So let's take a look. First, regarding the priority of a fixed charge. Right? The priority of a fixed charge. The priority of a fixed charge are being determined by the date of the creation. Quite simple, right? Quite simple. So normally you have to do the search, but if you fail, right? If you failed, for example, one person created a fixed charge on this table, another person also created a fixed charge on this person, right? That's possible. Because when the other one is not checking the company record, you can still sign a document to create a charge on the same thing, right? So, but when that happens, the solution will be very simple. When two persons create the same fixed charge on the same thing, then check the date of the creation. The one who created first enjoys priority. Simple, right? Simple for a fixed charge. But how about a fixed charge and a floating charge? Right? How about a fixed charge and a floating charge? So a fixed charge rank over a floating charge, regardless of the time of creations. That is important, and you have to be careful. Right? You have to be careful. A fixed charge and a fixed charge, simple, right? Just look at the date of the creations. But how about the fixed charge and a floating charge? It will be something like this. For example, right? So on the 1st of January, so a floating charge being created, right? A floating charge being created on the 5th of January, and then the fixed charge also created. Okay. Then on the 7th of January, the floating charge being crystallized, right? Crystallized. So it means it turned into a fixed charge, right? Turned into fixed charge. It means from this one, right? And this one want to compete with the fixed charge here. So who has the priority?
Fixed.
This one or this one?
Yes.
Second one, yes, right? Why? Because a fixed charge always enjoy priority, regardless of the date of the creations of the floating charge. So the floating charge actually being created earlier, right? And the fixed charge, sorry, a floating charge, yes, floating charge being created earlier, and fixed charge being created, subsequently, right? Later than that. But remember, a floating charge can only enforce when you crystallize, right? Only at the time when you crystallize, then you can become a fixed charge. So it means this fixed charge become a fixed charge. This floating charge turn into a fixed charge on the 7th of July. That's 7th of January, right? But this fixed charge created on the 5th of January. So this one is actually earlier. Do you get the point here? So, right? So the fixed charge enjoy priority over the floating charge, even the floating charge being created earlier. All right? Do you understand here? But you may have questions. You may have questions. So how about if the floating charge created and crystallized earlier? We look at the first paragraph. Right. We look at the first paragraph. A possible exceptions is if the floating charge was created before the fixed charge and it crystallized before the creation of fixed charge, then the floating charge enjoy priority. So the second case will be something like this. So on the 1st of January, so a floating charge being created, right? A floating charge being created, and on the 5th of January, being crystallized, right? And being crystallized, and then a fixed charge created on January. Right? Fixed it. Okay. Because based on the same paragraph, I told you that a fixed charge always enjoy priority, right? Over the floating charge, even the floating charge being created earlier, right? That's what you learned in the same paragraph. But there will be an exception. If the floating charge already crystallized on the 5th of January, then this floating charge enjoy priority. Why? Because the floating charge already turned into a fixed charge on the 5th of January, right? So according to the rules of fixed charge, the one earlier enjoy priority. Do you get my point here? If you understand, that will not be difficult. But if you have conceptual error, that will be very confusing. All right? So I hope that you understand. Okay? So how about priority of the floating charge? What happens? Right? What happens when we have two floating charges competing with each other? The law states that when they are competing floating charges, the case law illustrated that the first one created in time shall prevail when both of them crystallize at the same time. For example, a floating charge created on the 1st of January, floating, right? On the 2nd day of January, a floating charge also being created. Okay, but both of them crystallize on the 5th of January, right? Both of them crystallize on the same day. Then which one enjoy priority? The one created first. When both of them crystallize on the same day, right? But if one crystallize first, for example, right? If this one crystallized on 4th of January, right? But this one crystallized on 5th, then this one enjoy priority. Do you get the point here? Right? Because one crystallized, it turns into a fixed charge. And when it becomes a fixed charge, we follow the rules of the fixed charge, right? This one created first. Right? I hope that you understand. I know that's a little confusing, but try to understand. Right? When you're back home, you think about it again. And when you still have a problem, you can, talk to me next time. Right? Okay. But I want to ask you questions. Is it possible that I created a fixed charge? Sorry. Is it possible that I only have a floating charge, right? But I don't crystallize, but I still want to enjoy priority. Do you get my point here, right? Because when your floating charge being crystallized, it becomes a fixed charge. Then it enjoys priority of all subsequent fixed charge, right? Once crystallized. But I want to ask you questions. Can I do something that I'm just holding a floating charge, right? I'm just holding a floating charge. I never crystallized my floating charge yet, but I still want to make sure that I enjoy priority. Is it possible to do so? Yes, you can do one thing. When you incorporate something we call negative pledge into your loan agreement, right? A negative pledge. What's a negative pledge? Remember, page 30, some type of error. Check here and here. It's a new charge, right? You haven't yet changed it. A new charge, right? New charge. 呢兩個位打錯咗，跟翻呢個，right? This is the correct one. So what you can do, you can have something we call a negative pledge. The holder of a foreign charge may protect his interest by incorporating a negative pledge in his loan agreement. So that's the way to protect your interest. Why? A negative pledge is a provision which prohibits the company who is granting the foreign charge, right? For example, so I'm the bank, right? I'm the bank. So I already created a foreign charge on all the assets here. Right? I don't know which one belongs to me, but over all the circulating assets. So I don't want to make it fixed because that may be a problem regarding the operation of the company, right? I cannot create a fixed charge here. So I don't know which one belongs to me. So I just have a claim on it. So how can I protect my interests? Even I'm just holding a foreign charge. Simple, right? You have a negative charge. When the company promises that I will not create any new charge over the circulating stock here. Do you understand my point? I create a foreign charge, so I have a claim of a foreign charge over all the circulating stocks here, right? I don't know which one belongs to me. I don't want to crystallize, but I want to make sure that my right will be protected. I ask the company to promise me you never create a new charge on all the circulating assets here. Then my right will be protected, right? I don't have to worry about fixed charge, foreign charge, or anything. Because no new charge will be created. It means I'm the only one to claim for it. That provision we call negative pledge, right? And very important. So the purpose of the negative pledge is to ensure that the foreign charge will not be prejudiced by subsequent new charge, right? Okay, but do you remember in company law, we have a concept that we can ignore the internal problem of your company, right? Something like that. So it means that in general, so people can assume that so everything inside your company is fine, and I don't have to worry about any additional obligation in your company, right? In your company. So how to make sure that the negative pledge being learned by the subsequent creditors will be your main concern, right? Do you get my point here? That will be your main concern. So how to make sure that people learn about it? One thing. Do you remember the filing requirements here? This thing. Certify the copy of the instrument, right? When you file the form, when you do the registrations, you not just file the form NM1, but you have to file that instrument, the certified copy, including the negative pledge. You have to scan and upload to the company registry. So when people are doing company search, right? So when they are doing it, then they can notify your negative pledge. So that's why you have to file the certified copy of instrument, because that's the way to alert the others to learn about the negative pledge. So just having the form is not enough, and that's why we need to have the certified document, that instrument, right? Including your negative pledge. Okay, one more page before we end the class here. So you learned about fixed charge and foreign charge. Why I'm saying that it is a good security being created over the company? Because unlike just having a loan agreement, if you just have a loan agreement, if you want to enforce your right, then you have to sue the company, right? You have to sue the company in court. And only when you get the court order, then you can appoint probably the bailiff. Do you know the bailiff? Right? The staff from the court to carry out the civil order of the judge. Then you can try to realize the asset or anything from the company, right? It's a normal contract. But if you create a charge, no matter there's a fixed charge or foreign charge, you have the right, based on company law, to appoint someone we call as a receiver, right? Receiver, to exercise the right stated in your loan agreement and regarding your trusted asset. Do you get my point here? It means that when someone is not paying you on time and you create a charge already, then you have the right to directly appoint someone as a receiver to enforce your right without first suing the company. Do you get my point here? If you don't create a charge, if you just rely on loan contract, right, then you have to sue the company first. And then when you get a court order, then you can appoint a bailiff to do the enforcement for what you want. But if you create a charge, then you don't have to sue the company first, but you have the right to directly enforce, to appoint someone we call as a receiver to do the things you want, right? To take that asset, to realize your asset, no matter it's a fixed charge or foreign charge. So that person, we call that person as a receiver, right? 接本人. So sometimes you depends on the nature of your charge, because when the charge created over the general undertaking of the property, it means that a fixed charge over all the fixed asset, right? That is possible. You create a charge for almost everything, right? Or you create a foreign charge to cover the whole business. It depends on how you draft your loan agreement. When you cover almost everything, the entire operation, then you appoint that person as receiver and manager. It means that person not just taking that particular asset, but at the same time also need to manage the company, right? You have to file this form. 接本人、經理人, appointment of receiver and manager, right? Receiver, it means that person to realize that asset in particular. And manager means that person may involve in the management of the company. So it depends on the scope, right? Or how you drop that loan agreements. But just remember one thing. The mechanism of receiver and managers, it means it saves time. You don't have to sue first, right? You have a mechanism that you can rely on it. You can appoint someone just by filing the form. If the company is not agreeing with your actions, the company need to file the case to court to stop you, right? Because according to law, when you create a charge, you have the right to appoint receiver and managers to realize their asset. Okay? Okay, so that's all for today. So see you next week for the last lecture, right, in the Whiting Hall. So if you have any problem regarding the assignment, make sure you think about it and you ask me next time, right? Because when we meet again, that will be on April for a revision class. At that time, you already submitted the assignment, right? So you think about the assignment. Any question, you talk to me next time. Next time, that will be on Saturday. All right? Okay. See you next week.你 check 翻，我唔記得咗係，你跟翻 schedule 可能啱咗。Next Saturday 係嘛？唔係星期二啊？星期二唔係星期六我 sorry 我搞錯咗，星期二，星期二。你跟翻 schedule 我噏錯咗，
Yeah.
Next Tuesday, not Saturday. I'm sorry.
authorized share capital 是多少 ，issue share capital 是多少？所以当时我们还很就是这个问题。
現在未有這個問題，因為喺2014之後，2014之後，根據新嘅公司法，已經冇呢個分。
全都是 issue 的。
而家你可以 issue 幾多 share？ 睇乜嘢 price issue，完全睇公司嘅表現，除非你自己嘅 article 裏面寫嗰啲 restriction，如果唔係，你話 free to do so，完全沒有什麼 sense。
内地它其实如果说是要增资的话，它是要变更注册资本的，然后去重新再换一个执照，
这个跟香港
就不同的。
不同的开头。
我了解。
收得，全部收得。
咁呢度咧，即係分transfer shares 同埋 transactional shares 係咪？即係呢一個其實係正常，即係涉及到買賣
唔係
交易。
唔係，我先講先。係 transfer shares 係。
即係佢可以賣俾 existing members 或者係新嘅人。
但係呢個對公司嚟講係唔會有 raise new fund 嘅，因為只不過係而家一啲股東之間佢哋互相你賣俾我啦咁，或者我賣俾另一個啦咁，但係就唔符合我頭先講 insurance 嘅個概念，因為佢公司冇呢個要求用呢個。
係明白。另外咁即係 transmission 就係講佢即係權利即係 rights 嘅問題咁。
transmission 即係話有一啲情況下，佢點解會斷咗手咧？係因為一啲法律上嘅原因。譬如我講係阿爺瓜咗，係啦，阿爺瓜咗，個孫仔可以繼承，咁呢個係一個繼承法嘅問題，所以你叫做 operation of law，呢個係 succession law of succession 嘅問題，因為根據繼承法佢有權繼承，咁佢咪因為呢個原因而得到啲稅，咁呢個唔傾正難民，係啦，咁或者有個人俾人告，佢爭人錢，佢冇錢還，咁佢冇現金，但佢有啲公司嘅 share，咁人哋就有可能可以攞走嗰啲 share，轉咗落佢個名。就非常有 court order，咁嗰個又係叫做 operation of law，咁即係啲股票又轉咗手啦。第日唔係因為買賣，所以我哋就叫 transmission。
我另外想問一個 equity financing，你意思？頭先我聽你講話係即係要去到 winding up，間公司先會真係收翻啲錢翻。
係一般嚟講咧，如果你去 subscribe share，即係你幾多錢去買 share，一般嚟講你係唔可以攞翻。即係唔可以話俾間公司，你俾啲我俾啲話啲股票俾你，你俾錢我，一般唔得。除咗我哋上次講嘅例子就redeemable share，redeemable share 嘢就我哋講好唔同 share，有啲 share 喺某啲 condition 下係間公司可以同你買翻，可以 buy back。如果你唔係 hold 啲 share 咧 as a general rule 你係唔可以攞翻，直至間公司喺 wind up 嗰個程度裏面。如果你有剩，間公司竟然仲有錢剩咁平台，咁就 depends on 你係 hold owner share 或者 parent share， 或者你有冇寫啲咩 right 喺度，你有可能可以攞翻錢。但係濕住做好多嘢，但係通常都唔會有啦。理論上有可能，即係譬如間公司清拆咗之後，佢仲好多錢剩，咁佢可能要清翻佢，因為執笠啊間公司。咁我當時用10蚊買股票，佢可以俾10蚊，因為公司已經清盤啦，清拆咗嘢。但係因為間公司清盤時，佢要還晒俾啲有 priority 嘅人先。通常因為你係 shareholder 排得好明，所以通常間公司已經冇錢，所以喺現實情況係多數唔會攞到，但係理論上有可能。咁呢個我哋最後一堂會講，所以我講啲。
但係我想問咧，即係佢係喺即係我假設佢issue咗啲 shares 出嚟，跟住然之後我係買嘅時候，我就俾錢間公司。當時係。
咁你就叫做 insurance share，咁呢個先符合間公司去 raise 到分嘅原則，佢就可以用呢個形式去攞到錢啦，就係咁樣先得，因為佢要發啲新股先嘛，佢先可以攞到錢。
我明呢一個 concept，但係我唔明。
唔好明公股權，即係話因為你當間公司去發新股啦，公司只有發新股，佢先可以攞到新嘅錢翻嚟。咁而發新股佢有兩種形式，一種就 pro rata，即係符合現有比例嘅形式去發新股；另一種就 non pro rata，即係唔符合現有比例嘅形式。咁呢種就係符合現有比例嘅形式，我哋就叫做公股。我哋可以叫個商叫做公股名嚟㗎，冇意思。你可以叫 pro rata，不過喺商業上面有陣時我哋叫做 right， 或者叫公股，或者可以唔得你。
但係呢啲全部都係
總之跟翻現有嘅比例去供，即係根據你而家你 hold 10%，我就跟一個比例，令到你買完之後你都係一樣變翻10%。
即係唔會影響個 structure。
係啦，但係當然可能有人會唔買咯。咁最後個 structure 都可能有啲平，但係起碼我 offer 出嚟嗰陣時係令到你哋每一個人如果都買，咁你哋買完之後你哋個 structure 係冇變到。間公司又會揾到錢，但係你個 percentage 係一模一樣，咁樣就叫做掛多我哋都叫公股。
即係我明假設嗰度多一個人、5個人咁樣樣做嘅話，咁 就係嗰個 provider offer 係每個人20%咁樣。
我俾咗個例子咧，你可睇翻我個例子係佢4個人每人有25，咁你每間公司每個人再發多25咪就係 provider offer，因為每個人攞25之後，佢個 percentage 都係一樣，係嘛？原本由100歐獲25變咗200歐獲50，咪即係又係25%。啊，咁呢個我哋叫公股，呢個叫雞。
呢個 negative pledge 呢度咧，就防止間公司唔俾再整啲新嘅 fixed charge。
唔係 new charge， 我
咁係咪
錯咗呢個？
係 fix 係 floating 嘅俾佢，即係
new charge 任何
charge 嘅。OK， 如果公司唔做咧，即係我應承你好啦，我唔落啦，我唔加啦。咁如果我照做咁點樣咧？即係間公司會有咩？
嗱，第一
可唔可以做到無聲無息做到先？
佢照做咗嘅有2個 consequence 啦。咁第一就係因為如果你真係將你符合翻個 registration 要求，你係將你個 negative pledge 個 certified copy file 咗上去。
嗯。
咁即係話嗰份嘢咧，其實係其他人睇到嘅。
哦，係。
咁所以咧，你仍然會有人 join 下去。
嗯。
佢話即係唔 valid 嘅，其他人對你 claim 唔 valid 嘅。如果你跟晒所有嘅程序去 file 所有嘢。咁另一方面，一間公司兩樣嘢，第一可能有刑事。
嗯。
depends on